May I please, my lord?
Yeah.
My lord, I would like to mention item number 11. Here I am appearing for the petitioner. My lord, here the respondent during the pendency, my lord, he has passed away, ma'am.
Okay. So,
So
you
I may-
substitute
Yes, I may be given some time, ma'am.
item 11, counsel for the petitioner submits that the sole respondent
Sole respondent.
has expired and therefore substitution would be required and seek some time in this regard. So prayer is allowed. The petitioner side will take steps for substitution of LR of the respondent.
My lord. And
List after
3 weeks, ma'am,
4 weeks.
or 4 weeks.
List after 4 weeks.
My lord, there is an
Take some
interim
time.
order.
The interim order granted by the order dated so and so.
36, 2023.
36, thank you. 36,
23, 2023.
2023 stands extended till the next date of listing.
Obliged.
May I, Your Lordship?
Yes.
Also, I beg to mention item number 7 and 8, Your Lordship.
7
This-
and 8.
This matter to be listed after 2 weeks, Your Lordship.
You are for the government
Yes, Your Lordship.
petitioner, is that?
I'm for the petitioner.
Okay. Let it, after 2 weeks,
Yes, Your Lordship.
Learned government advocate appearing for the state respondents, praised for adjourning the matter for 2 weeks. Affidavits have been filed in the
Yes, Your
meantime?
Lordship.
Prayer is allowed. List the matter after 2 weeks. The learned counsel for the petitioner submits his no objection. Submits that he has no objection.
And Your Lordship, also item number 28, Your Lordship. In this matter, we have not received the Paraba's comment, so we
No,
need some more
Time.
time.
Item 28. Learned
28.
government advocate appearing for the state respondents seek some time to file the affidavit as the para-wise comments have not been received. Prayer is allowed. List the matter after
3 weeks, Your Lordship.
3 weeks. 27.
Yeah,
28.
28, Your Lordship.
Okay.
And also, Your Lordship, 29, Your Lordship.
Hearing matter.
Hearing matter, this matter to be listed after 1 week, Your Lordship. I've informed the other party, Your Lordship.
29. 6 1 week's time. With the consent of the other side, prayer is allowed. List the matter after a week.
After week, Your Lordship. Oblige, Your Lordship.
May I, Lordship? Okay. I would like to mention item number 16, Lordship. Okay.
16 1
Yes.
6.
Lordship, my senior Lordship, G. Lolen, Lordship, out of station. Lordship.
Another day you want?
Yes, Lordship, after 2 weeks, Lordship.
You're for the respondent. Petition. He is for the respondent.
Yes, yeah, all the respondent.
Nice. Let it be. Any interim orders there?
Yes.
Interim order. No problem. 2 weeks.
Yes. Interim order may come.
The learned counsel for the respondent. All the respondents.
Yes, Lordship.
All the respondents seeks an adjournment on the ground of the leading counsel being outstation. Prayer is allowed. The petitioner counsel fairly submits that he has no objection. The interim order, side order dated so and so stands extended till next date of listing. And list the matter after
2 weeks, Lordship.
2 weeks.
Much obliged.
My lord, I beg to mention item number 17, my lord. My lord, herein both the conducting councils, they are seniors, learned seniors who are appearing from Guwahati.
Mhm.
So on their prayer, we are seeking for a fixed date. That is on 12th of this month. My
12th
lord.
of this
Yes, my lord.
The counsel from would be applying appearing online mode is for the petitioner.
No,
Yeah,
they
no.
will be coming.
They will be coming, appearing here.
For the petitioner.
Yeah, they will be coming.
I see. The learned, your good name, please.
B. Nearus.
Learned counsel for the petitioner side submits that the leading counsel for the petitioner side is stays outstation and prays for fixing the matter on 12th of November, which is not objected to by the learned counsel for the respondent.
Yes, sure.
Also, list on 12/11.
11.
Yes, my lord, there is one more matter. Item number 10, my lord.
Any interim orders there?
No.
Item number
10.
10.
Here, my lord, I am on behalf of the conducting council, R. Sonar, my lord.
Right.
He is currently indisposed of due to ill health, so it may be listed after 2 weeks. And
On the
my lord,
prayer
I
of
wo-
the learned
yes.
council, the matter may be listed after 2 weeks as the leading council is stated to be unwell. Full stop. List after 2 weeks.
Yes, my lord. My lord, I beg to mention one unlisted matter also. It's a bail application
Oh, for today,
for today, ma'am. If you-
My lord, I would like to mention item number 6.
6. Yes, tell me.
Due to medical emergency of the leading council, matter may be adjourned.
Adjourn for the petitioner side to medical reasons. After how
May-
long?
No, maybe listed on Monday. Monday.
This month.
Yes.
List the matter on, how about Tuesday?
Ah.
The list. Okay, as you wish.
Okay.
10, 11. Monday only.
Oblige.
Yeah, my lord. My lord, I beg to mention item number 27, my lord. As per the, my lord, last
Okay.
order, I was supposed to take a fresh step, my lord.
Hmm.
So I may be allow some time for.
For the
taking-
petitioner, you're for the petitioner?
Yes, yes, my lord.
Press steps upon one of the,
Respondent number 4 and 6, my lord.
nice. Your good name, please?
NUB, my lord.
Learned counsel, NUB, learned counsel appearing for the petitioner, item 27. Seek some time. 6 an adjournment for the day as steps remain to be taken upon respondent number 3 and 4.
No, 4 and 6, my lord.
4 and 6. They are private respondents, no?
Yes,
4 and
there is,
6. Never mind. No, 4 and 6. Prayer is allowed. List after 2 weeks.
My lord,
You're for the respondent.
yes, respondent 3 and 4.
Okay.
And still not punish us extra copy.
Hmm?
Still not punish us extra copies.
Yes. The petitioner side, that the learned counsel appearing for
3 and 4.
3 and 4 submits that extra copies may be furnished to them as they have not received. The same may be done. Please furnish it.
Okay,
If not ready today, then Monday.
okay, my lord.
List after 2 weeks,
3 weeks, my lord.
3 weeks.
Okay.
We have that matter no? To complete. Yeah. Someone is appearing online.
Yes. Lordship, in this matter, in reply, Lordship.
Okay.
Yesterday I. Yes, yesterday, I have submitted my part, but I have to cite some citations, additional citations and some reply. In this case, I will say, Lordship, there is a contradiction.
Hmm.
Finally, so these paperwork here, because 161. 161 statement of the, that is not enforced in the paper book. So
Usually 161 statement, sometimes I've seen earlier also. It's not, sometimes not given in the paper book.
just for corroboration.
Hmm.
Corroborate. Since the PP is saying that here is a.
But you are entitled to a copy.
outside.
Hmm.
Because they're saying that the whom the victim has disclosed. Victim has disclosed. Kindly see.
You have the setup 161, no? Otherwise 207, you must have got no? That copy.
Statement
Use that, you know. Usually I've seen it's not in, given in the paper book. Hmm.
Lordship,
That page,
page number 5 of the paper book. Paper book, statement of the Mamoni, Mamoni
Mandal.
Mandan. Report
audio-
of MFC passing act.
Switch off the audio.
Page number 5.
Switch off the audio. Council, your good name, please.
A. Ghoshal on behalf of M. Bishwas.
A. Ghoshal on behalf of A. Biswas, learned
M. Bishwas,
council, and M. Biswas, learned council for the petition. Seeks an adjournment of the matter due to personal difficulties. of the leading
Yes,
council,
Your Lordship.
due to some unavoidable personal difficulties of the leading council. And 2 weeks adjournment. The prayer is allowed. List the matter after 2 weeks.
Lordship, there is an interim Lordship that may be
The
continued.
interim order, past fight order dated so and so, stands extended till the next date of listing, right? Next
Obliged.
after 2 weeks.
Obliged, Lordship.
Registry will fix the date. If it doesn't come, you make a mention.
Lordship.
Done? You can log out. Yeah. Proceed in the list.
Item number 2. May I please, Your Lordship? Your Lordship, this is a joint criminal petition, Your Lordship, filed under section 5 to 8 of BNSS 2023, Your Lordship, seeking for quashing the criminal proceeding, Your Lordship, in Papu Hill PS case number 37 of 2024, Your Lordship. Your Lordship, this is a matrimonial matter, Your Lordship, arising out of, Your Lordship, the personal discord between the legally wedded couple who have now reconciled and resumed normal marital life, Your Lordship. Your Lordship, here in this case, Your Lordship, the fact of the case is that, Your Lordship, petitioner number 1, Your Lordship, who is the wife, has had earlier lodged an FIR on 23rd July 2024, Your Lordship, alleging assault by her husband, Your Lordship. That is petitioner number 2, Your Lordship, due to extramarital affair, Your Lordship. And Your Lordship, accordingly, Your Lordship, the case was registered, Your Lordship, under section 115 and 85 of the BNS, Your Lordship. And the charge sheet has already submitted, and the case is before the CGM UPI, Your Lordship, at the stage of CC, Your Lordship.
Nice.
Your Lordship,
Both husband and wife are the petitioner.
yes. Your Lordship, after lapse of some time, Your Lordship, both the husband and wife amicably resolved their differences on 3rd September 2024, Your Lordship, in the presence of all the family members and the village elders. And they executed one deed of agreement and declaration, Your Lordship, that whereby the petitioners undertook that he will not harass or assault his wife also in future, Your Lordship. So in this connection, Your Lordship, pursuant of this settlement, Your Lordship, the petition number 2, petition number 1, that is the wife, Your Lordship, they voluntarily submitted one withdrawal application before the concerned PS, Your Lordship, to drop the case, Your Lordship.
Before the consent PS?
Yes, on 4th September, Your Lordship, on 4th September 2024, Your Lordship.
Now it is at the stage of CC.
CC, Your Lordship. And thereafter, Your Lordship, one to whom it may concern also
The
be
case was
exhibited.
the case was registered on the only 498. 115 and 85 BNS. Now it's 85 BNS, right? This is
Yes.
498 days, 85 BNS. Okay. So at this stage, what we can do is you accept notice
Yes,
and
Lordship.
we
All 4 days,
all-
can copy of.
yeah, can copy and we can stay further.
Yes,
process.
Lordship.
Yes,
That will
yes.
be
Your Lordship.
reliable. The your good name, please.
T. Game, Your Lordship.
Learned Counsel appearing for the petitioner. 2 petitioners. Full stop, who have invoked the 528 of the BNSS, sorry, for quashing of criminal proceedings arising out of Papu Hills PS case number 37 of 24 under 115/85 BNS corresponding to GR case number 1293 of 24. Full stop. The case is presently stated to be pending at the stage of consideration of charge in before the court of the learned JMFC,
CGM
Learned-
UPI.
learned CJM, which
U-
is
UPI.
UP. Full stop. Based on a complaint lodged by petitioner number 1 against petitioner number 2, stated to be her husband, the aforesaid case was registered, which after investigation was charged sheet leading to the aforesaid GR case. The Learned Counsel contents drawing attention to the relevant documents that both the parties being husband and wife have compromised the matter. And in this regard, an agreement has also been made and submitted before the concerned police station. In the aforesaid facts and circumstances, the petitioner are seeking quashing of the criminal proceedings. The petitioner shall furnish copies of the necessary copies to the learned additional public prosecutor for the state. A call for the scanned copy of the case diary and charge sheet. That will do. We know we don't
Already
need.
translated, then call for the scan copy of the teacher record.
Entire record may not be necessary. Usually, you can write like this: call for the scanned copy of the TCR, comprising case diary, charge sheet,
Yes.
and other relevant documents.
Yes.
Because depositions are not there, so
No,
it may not be necessary.
yes,
Only charges are necessary. Actually, we need that thing, which is, of course, I'm believing you, of course, but for procedural propriety, that document which is submitted before the police station, that should be in the case diary.
But it will make
It should be
case
in the
very
case
lost.
diary. In the circumstances, I also deem it proper to allow the prayer for stay accordingly. Further proceedings of GR number, that one, pending in CJM, shall remain stayed till the disposal of this criminal petition, till the disposal.
Next returnable date was.
Usually it's given like that one.
Say.
So you prefer next date of listing, because this is apparently, anyway, next date of listing,
Last.
next date of listing. List the matter after
3 weeks, 3 weeks, no?
No, 3 weeks.
3 weeks.
after 2 weeks.
Like-
Much of that. Item number 3.
Please, your lordship. Your lordship, this is an application under section 528. Basically, in this application, your lordship, we have challenged an order of recalling the IO at the stage of argument. This is in respect of POXO trial, your lordship.
Okay, changing the IO,
Recalling the IO
recalling the IO for
IO
examination,
for examination at the stage of argument, your lordship.
which was not allowed.
It was allowed, your lordship. We are the accused, your lordship.
Okay, you are agreed by recalling.
Yes, recalling order. Your lordship, the basic fact is that, your lordship, this was a case under section 6 of POXO Act.
Can we see the impugn order?
Impugn order is at page number, your lordship, 56. 56. Your lordship, it starts from 56 and 62. So should I read, your lordship?
As you wish, you can read it. It's a bit long. Or if you want me to flip through, then I can also.
Your lordship.
Yes,
So
let me do it.
before that, your lordship, may I just delve into certain important facts so that we can understand this? Your lordship, the case was, the allegation, the FIR is there at page 21, your
Yes.
lordship.
That will be better. See the FIR.
Page 21 is the FIR and typed copy is at page 23.
Yes.
Sir, it is to apprise of the brutal rape case of a minor girl of 16 years of age. Girl is a student of IGGHS, Pasighat, studying in class 12. As per report, the girl was returning home after classes wherein she was asked to come for syllabus for exam by her English teacher, Sri Nong Jamo, working as a junior teacher at IGGHS, Pasighat, to his residence at Baskota, Pasighat, on the pretext of giving her the syllabus for exam. The ignorant girl obediently went to meet the teacher.
Upon the respondent number 2, informant. In terms of the stipulated procedure, right? And the call for the
Scan copy of the TCR record was.
call for the scanned copy of the TCR comprising the relevant documents for the for assistance in adjudication of this matter. It is from which district, ma'am?
Let's say East Siang
East
District,
Siang.
Pasiga.
East Siang,
Yeah.
Pasika. Okay. We have to decide it within November, this matter.
Yes,
Has to be
Lordship.
decided. It can be, it can be.
Yeah.
It can be. In the meantime, you look up the case laws. Madam, you also look up.
Yes,
I will
Lordship.
also study
Yes, Lord.
at this parable. In the context of this, the query I posed, but suppose it is not done, then will it make it invalid automatically or not necessarily so, or test of prejudice,
Yes.
something like that?
Yes.
List, first date, when should I fix? You can suggest. What is it?
Lordship, November.
You're from here or outstation?
Outstation.
So you-
From Assam?
Yes, Your Lordship.
As per his convenient, Lordship. And
For the records and all, if it's not, for steps, you can appear through VC also, not a problem. For the main thing, you come.
Lordship, then Lordship.
Both of you suggest.
Then Lordship, this is Poxo matter, Lordship. Then respond number 2, Lordship, it will go to the office of the PP, Lordship.
Yes,
So
the steps will be sent to the concerned police,
yes.
to the office.
In office of the PP.
It will go. Notice will be served to the concerned police station.
Yes,
to you.
Lordship, through our office, Lordship, PP. office.
Because it has to be eventually served in order to expedite the
Yes,
disposal.
no, no, it's done like that only.
Then
So-
Date,
You can suggest me that. I'll go by your date, no,
can it be a week or 10 days?
It can-
20th November,
it can be if it comes, why not?
24?
24 November,
20,
Monday.
Monday. 24/11, right?
Yes,
24/11. No.
deeply obliged. sir.
Deeply.
Item number 4.
Ma'am. So going into the fact of the case, I am referring your lordship to Perus one annex of 61. This is the notification issued by the government of Arunachal Pradesh.
Page 61.
61. Annex 13. Married. To all the commissioner, additional deputy commissioner, Arunachal Pradesh. Subject regularization of all government land under occupation of private individuals, state and central government establishment and cabinet decision thereof. Sir, a large number of cases of occupation of government land by private individuals, state and central government establishment in all districts as well as in capital complex have come to the notice of the government. The matter was reviewed by the cabinet meeting held on 2nd May 2012. The cabinet had taken serious view of such a situation and directed to take following action immediately. Regularization of plots occupied by private individuals. State and central government established in a time-bound manner in all districts, including capital complex, after proper survey and verification as per existing acts and rules and realization of rent premium and lease rent from the debt occupation. The point number 2 is not relevant in the case, no, last portion. Therefore, all deputy commissioner, additional deputy commissioner, land revenue and settlement officer are requested to adhere to above instruction and ensure that regularization work is done in a time-bound manner as per the Arunachal Pradesh Land Settlement Record Act 2000 under section 12(2). Correct. This notification is still standing.
Okay.
Now my
Though it dates back to 2012, it's still,
there.
it's still there.
Now my case is that, Your Lordship, I have occupied a plot of land in the year 2001 in
Mhm.
Daporito. Your Lordship, thereafter, I have applied for the regularization of the same in the year 2006. Your Lordship will find at page number 37 onwards, Your Lordship. My application, 37. This is the application, Your Lordship.
Hmm.
Dated Daporito, the 5th January 2006. With profound regard and humble submission, I would like to state you to this. I'm born and brought up in Daporito town since Union Territory, and my parents too was spent their life in Daporito town through the Chinese segregation. In light of the above context, none of the members of the parent have not acquired any plot of land, either residential or commercial plot. So far, even if the bundles of applicant has drawn the authority for its allotment right from the NEPA administration. Now, I being the citizen of country as well as bona fide in the district, look ahead of my future to engage as self-employed by establishing the business network in my hometown
in which plot is extremely needed. Meanwhile, I have occupied plot of land at RCC boundary wall of executive engineer electrical power complex area near veterinary farm. So I have submitted my application in regulation along with the skate measure.
Mhm.
Thereafter, Lordship, the land management department, the authority concerned, has verified my plot of land
Mhm.
by a spot verification. And your Lordship will find verification report at page 4, Your Lordship.
40.
Yes, 40. This is the verification report. Your Lordship. Back copy is page number 41. Your Lordship. May I read your verification?
Hmm.
As directed by the CO Land Management on 18/4/2006 to survey the plot of land for residential purpose in respect of Sri Dati, that is petitioner, near Power Grid Department, Daporejo. I have been verified the said plot on 24/2006. It was verified on 2006 itself. As per the conduct of verification of the field survey, the plot is feasible for the residential purpose. Therefore, authority may like to approve the case, please. Now, the recommendation is also there, Your Lordship.
Mhm. Okay.
At the bottom, Your Lordship. Place it before next Dalab. Earlier, there was a board for the land allotment, Your Lordship. Now it is not there.
District land allotment.
Yes,
agreement.
it was a
Now
board.
it's not there.
Yeah, it is not now, but it was there. earlier.
Now it is done by the office of the district commissioner.
Yes, Your Lord, District Commissioner. So my case was to be considered in the year 2006 itself, since the recommendation was made in the 2006, Your Lordship. However, it was not, Your Lordship. Thereafter, after the lapse of, Your Lordship, more than 20 years, I was surprised to get an order from the Deputy Commissioner in charge, Your Lordship.
Rejecting it.
No, Your Lordship. Your Lordship, kindly page number 44. Your Lordship. There was a complaint from Badminton Association against me, Your Lordship, that I am disturbing, hindrances, obstacle in their badminton hall, Your Lordship. It's a multi-purpose hall, Your Lordship, and the players had lodged a complaint against me, and I have never punished with a complaint of these people, Your Lordship. Kindly see, Your Lordship. Based on the complaint received from the badminton club under the Upper Subansiri District Badminton Association regarding encroachment and obstruction caused by construction activities undertaken by Sri Dos Dasi near the establishment, and further based on the verification report submitted to the undersigned, the following observations were made. It was observed during the verification that Sri Dos Dasi is constructing a structure very close to the officer badminton club, causing significant hindrance and inconvenience to players using the facility. This order has been passed on 28 March 2025. Your Lordship, it is admitted that I was in opposition party, Your Lordship, and this order has been passed after the just completion of election, Your Lordship. So I have stated in my representation that it is purely a political motivated complaint against me, and based on this complaint, Your Lordship, I have submitted my representation. It is in page number 45. Lordship.
But, this, anyway, prima facie, okay, that's okay. This recommendation was made way back, right?
Yes, in 2006, Your Lordship.
But it was, after that, it was not settled,
No, Your
not
Lordship,
settled.
not settled, Your Lordship. So I humbly pray that
But you, after this, I mean, if not in 2006, when it was not settled despite the recommendation, and especially after the notification, I'm just asking. After this notification, favorable notification
yes,
for you,
yes.
it came in 2012, you did not ask them again?
No, Your
to
Lordship,
settle it?
because I wasn't aware of this notification. So I was of the bona fide impression that my land will be allotted to me, since I have already
No, because as you know,
double storage RCC building at my plot of land
anyway.
in the year 2023 itself. And now this complaint has been lodged in 2025. So, Your Lordship, instead of keeping this matter pending, Your Lordship, I humbly pray that my representation may be disposed of in terms of
Where is your representation?
my representation is, Your Lordship.
Ma'am, government can take instructions, I think.
Yes, ma'am.
At this stage, going into the stage of affidavits might delay, as you said, if you want a speedy, we can try for a speedy, and initially it will be better to take in instructions, and then, whatever is the status, then, as per his prayer, we can consider that option of
Yes, that's
this
so.
directing the representation to be considered. What do you say? What do you say? Where is your representation? Can we see?
It is in page number.
No, you feel free to submit any other alternative route also. Page 38.
50, Your Lordship. This is my representation.
Yes.
Representation of reminder for residential land, Your Lordship.
Okay, this is up to date, right? So,
Your Lordship.
Hmm.
I have submitted my representation, reminding that my land allotment application is still pending, Your Lordship.
mhm.
So I humbly pray that, Your Lordship, this representation may be disposed of in terms of the notification of the 2012, Your Lordship.
If I give a direction today, it's all.
My
that will
kindly
be
see, my lord, by page number 60, my lord,
six-
in order,
six-
60, my lord. Here, my lord, it seems, my lord, petition has filed an appeal, my lord. After that, it has been disposed of, my lord.
Just a minute.
Page number 60,
Let me see. this,
and
huh?
excerpt 12, my lord.
Let me see his representation. also. The outline. Mhm. Then page 60, what has been done? Is recorded
Yeah, my lord.
petition of has been heard. Regarding the eviction notice.
After the notice was issued, my lord, the petitions filed an appeal, my lord. After that, it-
No, that is with regard to the eviction.
yes, my lord.
Page
Eviction.
59, the impugn order is page number 59.
You got a eviction notice for the entire land to vacate.
Yes, Your Lordship.
Instead of settlement, they're evicting. They're
Yes,
trying to evict. That's what you were saying, no? And the appeal has also been rejected.
Yes,
rejected.
Rejected.
Without mentioning any reason, Your Lordship, in the appeal, Your Lordship. Only they have stayed the impugn order. Your
That would be better. You take instructions. That will be better.
Lordship. Really,
Oh.
in the meantime, Your Lordship, I may be protected with the interim because I have no any other option to stay with my family. Your Lordship. This is the only place where I'm staying with my family.
Land council, good name, please.
I, Babu.
Ivan. For the petitioner who has invoked the constitutional jurisdiction under Article 226 of the Constitution, seeking a writ/direction, and also agreed by order dated 12/9/2025, passed by the learned additional Deputy Commissioner cum Estate Officer, Upper Subansiri District, Daporizo, AP, in order number, guide order number LM slash, just page 2, lift it from here, LM slash DRJ dash 18 slash 22. Full stop. The basic facts projected by the petitioner side that he has occupied a plot of land at RCC boundary wall of electrical power complex near veterinary fodder farm Daporizo. And he made a request in 2006 by his letter dated 5/1/2006 for regularization of the said land occupation. On the basis of the same, field verification report was done, which is stated to have returned a positive finding in favor of the petitioner. And it was recommended that the said regularization may be done. In this regard, the petitioner has referred to a verification report dated. What is the date of the verification report? Verification
One of
report.
24 to
Anyway, so verification report only. Annexed as annexer 2 at page 40. Full stop. There was also a recommendation, noting in the said report for placing it before the concerned board which existed at that time. It is contended that, however, and whatsoever was taken, and in the meantime, in 2012, notification number LM dash, we'll need this for subsequent orders also. LM dash 102/2010 dated 24/5/2012 was issued by the government of Arunachal Pradesh Land Management Department regarding identification of lands occupied government lands occupied by private individuals and taking steps after verification for regularization of the same and realization of land premium and lease rent on the date of occupation. Full stop. It is contended that despite such a notification, the land was not regularized in favor of the petitioner. Rather, white, which is the notice which you get, white notice dated, he was directed to be evicted based on a complaint from the Badminton Association. Full stop. It appears that subsequently an appeal preferred by the petitioner with regard to the notice of eviction was also rejected by order dated 24/10/2025. In this backdrop, the petitioner has come before this court seeking regularization of his land and also prevention of the eviction sought to be done. Heard, learned, government advocate for the state of Arunachal Pradesh, who undertakes to take necessary instructions in a matter. The learned petitioner counsel submits that in the event of some interim protection, he may be prejudiced. I've given my consideration to the matter since this court has agreed as part of his jurisdiction to look into the grievance of the petitioner. It is directed that till the next date of listing, he shall not be subjected to any coercive measure with regard to the concerned property in the interest of justice. Otherwise, it will create complications. There may be more litigation, ma'am. That is also reason. Maybe more litigation also, civil litigation. So that will be better. At least the matter you can suggest.
On 18th, my lord,
18th of
November.
1811.
Yes.
I'll take just 2 minutes.
Item number 5.
My lord, are serving as assistant engineer under RWD, my lord. Initially appointed as junior engineer in year 1995, 1997, and 2001. Officer comes under zone of consideration for promotion, my lord.
Okay.
To the post of assistant engineer, my lord, in the year 2002, 3, 5, 6, and 9, my lord. And my lord, petitioners were given officiating appointment, my lord, promotion, my lord.
Okay.
In the year 2013 and 17, my lord.
Okay.
And
What is their prayer in this?
my prayer, my lord, for a direction to respondent authorities to convene review DPC to consider a case of petitioners for assigning national promotion, my lord. In terms of
From the date of their officiating promotion.
yes, my lord, and in terms of cabinet decision, my lord. 0172.
At this stage, we issue notice.
Yes, sir, my lord.
Notice.
Heard so and so. Learned counsel. The merit petitioners, 28 in number, invoking jurisdiction under Article 226 of the Constitution, seeking a direction to the respondent authorities to convene the review departmental promotion committee and consider their case for notional promotion from the date of the vacancies,
Yes, my lord, vacancy, my lord.
date of the identified wise vacancies. Just write for comma as reflected in the prayer portion of the writ petition. I'm just, because I have not gone into the matter, right? Stop. It will help for future. 6 respondents have been impleaded, comma, out of which respondent number 5 and 6 are private respondents. You will accept notice on behalf of all the four,
1 and 4, Your Lordship.
1 and 4 only. Learned,
Yes.
government advocate.
Yes, K. Sangeeta.
Yes, he accepts notice on behalf of respondent number
1.
1 and 4, and you will be, and learned, you also got standing council,
Standing
standing rural development, 2 and 3. Okay. Okay, rural development. The standing council, you said, standing council, rural development, it's called? Rural work. Learned council, so and so. The standing council, rural works department, RWD within bracket, accepts notice on behalf of respondent number 2 and 3. Please. The petitioner shall furnish extra copies if needed to the learned councils. The petitioner shall also take steps for notice upon respondent number 5 and 6. List the matter after 4 weeks. After 4 weeks. In the admission column, no, it can come in the admission column this time. It can come in the admission column since we have issued notice. Orders.
Orders, ma'am.
Yes, yeah. List in the orders column. Item number 9.
Your Lordship, respondent number 5 has filed the affidavit in oppositions. Today I have just received.
Just a minute. This is done. Which items? This one is which item? 9.
Item 9.
Item 9.
These two are adjourned, nice. So, yeah, respond number, private respondents.
Yeah, private respondent has filed their
5,
opposition.
respond number 5.
Yeah, I'm from the petitioner.
You have the petition.
Your Lordship, I'm appearing for 1 to 4, Your Lordship. We have filed already.
Already filed.
Yes.
The pleadings are complete. That is.
Yes. Your Lordship.
So I will, I have to file the rejoinder.
Oh, yeah, you have.
Yes.
If you file a rejoinder, then it's not complete. Land matter, right? It's a land matter. Heard learned counsel. Your good name, please,
T. Nega.
for the petitioner, who submits that in the meantime, the respondent number 5, being private respondent, has filed his evidence and affidavit. Learned government advocate appearing for respondent number 1 to 4
Yes.
submits that the state respondents have also filed their affidavit in opposition. In total, 5 respondents have been completed. The petitioner council submits that the petitioners would like to file a reply to the affidavit. Prayer is allowed. List the matter after
3 weeks.
Okay.
Always.
with the number 12.
We have filed our affidavit.
Affidavit.
Yes. Okay.
No, it is a criminal.
No, Your Lordship.
Criminal activity. You see the last one. Steps upon respondent spending, right? Look. Prosecutor is appearing. Nobody is appearing. Anyways. None appears at present, full stop. Peruse the previous order dated 3/6/2025. It appears that matter is pending for service of notice upon the respondent number 2/private respondent. the prosecution shall take instructions from the concerned police station, through the concerned police station, regarding service, regarding completion of service upon the respondent number 2, private respondent. Is the matter after a week.
Item number 13.
It appears that the paper book is also ready. Item number 13. Writ petition. This is
My pleasure. No, see, this writ petition seems to be bulky, but the issue is very simple, termination of service,
one should never get intimidated by file, right? So,
Exactly, No,
though we usually get
yes.
in a way,
No,
joking.
the petitioner.
Oh.
Petitioner were serving as PRT, TGT, UDC, LDC, and MTS, And while serving, without affording any opportunity of hearing, we have been terminated from the service, by the impugn, the series of the termination order.
No illegal appointments were not illegal, right?
Admittedly,
They were-
some appointments were made, regularized, service were regularized. Earlier, they were serving in the department of the SSA, initially,
Give me
On
2 minutes. I'll have a look at the synopsis.
Yes, Now,
Just okay.
Now, what happened? Without entering into the merits of the case, during the pendency of these writ petitions, what happened? The other similarly situated persons were regularized, reinstated by the respondent department, saying that this pendency has bar for them to consider my case, Therefore, in the additional affidavit, straight away, what I'm praying for, is matter may be remanded back to the concerned department to re-verify the process is done in the other case. May I take your lordships to the affidavit, additional affidavit filed on 4th November, additional affidavit,
Page.
Page number, 6 November, I'm sorry. Page number, it is internal page number, 234, annexure 2. As I have pointed out, without going into the merit of the case, the department is ready to re-verify this petitioner's the appointment
A
process.
similar order was passed in
Yes,
connected writ petition.
Yes, And the page number, my additional affidavit, last additional affidavit filed on 6th November. It is in annexure 1, Sorry, annexure 2, page number 234,
234.
Yes, Orders, The same similar order, they were the same order by which their services were also terminated. However,
Here I found it.
Additional-
234, this is on the basis of, this is the order dated 2/11, right? 2020. No, am I on the right?
order dated 17 December 2024,
Additional
additional affidavit, filed by the petitioner.
Yes, yes. on
Yes,
this-
no.
okay, this-
Married, same addition, the order by which they were terminated, whereas the following multitasking so and so, it is of course one department. They terminated from the service by office order number, this is the termination order dated, on the ground of illegal appointment. Whereas after go through the verification of all the records, it is found that the appointment of these MTS were made on the basis of the departmental promotion committee they conducted at district level. However, the approval from the competent authority was not taken, which is a procedural lapse. Now, therefore, considering the genuineness of the case, the recommendations of the verifications committee for illegal appointment, the authority has decided to revoke the termination order of the following multitasking and reinstatement their service. Serial number 1, all terminated. they were also terminated. Similarly situated person, my lord, in my case also, my lord. And thereafter, my lord, we are time and again, my lord, consistently, my lord, approaching before the, my lord, concerned authorities for reconsideration, my lord. But the authorities are saying that your matter is pending before this honorable court. So therefore, they are not in a position to, my lord, reconsider my case, my lord. Therefore, my lord, at this stage, my lord, may I pray, my lord, without entering into the merits of the case, my lord, direction may be given to the, my lord, the respondent authorities to reconsider my case, my lord. Just simple, my lord.
That's okay, but yeah, because so many, there are pleadings, considerable pleadings, it seems. Now, you make your submissions.
My lord, as the petitioner counsel must say, my lord, regarding my lord, remand, there's no issue, my lord, because similarly situated, the department,
No issues.
they have reconsidered, my lord. In that case, if they, after having reconsidered their case, if they are found eligible, genuine, their case can be, the authority may consider for reinstation of their case, my lord, without enter into merit, my lord.
Merits, okay.
My lord.
My lord.
Can it be disposed?
That,
like-
my lord.
Yes, my lord.
Remanding back the authority to reconsider. If their case genuine, they can be considered for reinstatement.
My lord, that is
As
only
like
our
the-
favor, my lord.
As like the other cases that have been done.
And no opportunity admittedly was given, my lord. So at this stage, my lord, with the directions to the, my lord, respondent
Leave up
authorities.
to the authority, my
My
lord.
lord.
They can exercise.
Fair enough, my lord.
All are state respondents, all are state.
All is
respondents.
no private.
All are,
respondent.
no
Yes,
private,
madam.
no
1 to
private.
12.
You are representing all of them.
Yes,
Okay,
one
then
to
it's okay.
12.
If you have submitted, then it's okay. That's fair enough. Please sit down and you can,
Well.
in between, I might need some help with the
Well.
facts and dates.
Well.
Right? Now, we know this, no? This irregularity is curable, but illegality may not be curable.
That is
So
why, madam.
principles of natural justice would certainly be applicable if it is maybe irregular. Right?
Irregular,
You know,
right.
at least they can still be terminated in some situations.
Well.
Yes.
But that process has to be followed. But
Yes, ma'am.
if it is outright illegal something, then maybe it may not be necessary.
Exactly, man. Exactly. That's why the authority will look.
The authority can still give a notice, but I mean, it may not be essential. That's the law, isn't it?
Exactly. That is
Madam, that's why without interfering with the impugn order, madam, maybe authority may be directed to re-examine the matter if they found with the leave up to the wisdom of the authority.
The third, so if I need some help in that, the read petitioners,
188 in
no,
number.
I'll find, this will, I'll find, 188 in number, have invoked the constitutional jurisdiction under Article 26, seeking read/direction with regard to their grievance being terminated from service without complying with the principles of natural justice and seeking interference with the same by way of reinstatement as well in service. The writ petition has included as many as 12 respondents who are represented by learned
Standing counsel for
Stand-
education department.
education, learned standing counsel, learned standing counsel for the education department. At the outset, the learned petitioner, counsel for the petitioner, submits that he has a limited prayer at this stage, in the sense that without delving deep into the merits of the matter, perhaps the matter can be remanded back to the respondent authorities for verification and reconsideration of the case of the petitioners, as has been done, as has been stated to have been done in the case of some similarly situated persons. Full stop. Before proceeding further, it may be mentioned herein that the petitioners were appointed as these facts will be otherwise it will be very
There are one.
bland.
Page
order.
31, 39.
The petitioners were appointed as as primary teachers.
Correct.
Primary teachers, trained graduate teachers. The petitioners were appointed in different capacities under the education department as dash, primary teacher, trained graduate teacher, lower division club mother, under the Directorate of Elementary Education, Department of Education, Government of Arunachal Pradesh. Full stop. They were appointed when they were appointed in 2000.
Ranging from 2017 to 2022.
At time periods ranging from 2017 to
22.
2022. This is the base facts will be necessary. Full stop. It is contended that, however, by order number, it will be 39, page 39. The order number, it will be block code, so 120 dated 16/11/2023, and order number dated, both are 16/11, order number EED 10215/5/2022. Issued by the respondent number 2, being the Undersecretary within bracket Education to Government of AP, Itanagar. The petitioners were terminated from service. Representation was submitted, right?
Yes.
Agreed by the, highly agreed by such termination. The petitioner submitted representation dated 28/11/2023 before the respondent authorities for review and reconsideration of the termination orders and for reinstatement. But it is contended that the same remains unattended by the authorities till date. In this backdrop, the writ petition has been filed. You have filed one common affidavit, one affidavit.
Yes.
You filed. The respondent, one affidavit. Affidavit in opposition has been filed.
Yes, one affidavit.
All the respondents have filed a common affidavit in opposition. Full stop. The learned counsel for the petitioner has drawn the attention of this court to order. Let us go back to that order, which is that order you have referred to. Has the learned counsel for the petitioner side has filed an additional affidavit. I got to cut it. The petitioner side has filed an additional affidavit, and learned counsel for the petitioner has drawn attention of this court to where was that document? 234.
First order.
To an order dated 17/12/2024, passed by Commissioner Education, Government of AP, which is annexed as Annexure 2 of the additional affidavit available at page 234. In this context, the learned counsel submits that by the said order, 4 similarly situated persons were the case of termination of 4 similarly situated persons was reconsidered, and they were directed to be reinstated. The relevant portion may be reproduced here in below. Second to after verification, and page 234 of the additional affidavit, whereas and now therefore, these two second paragraphs. The learned counsel submits that as already contended at the outset, as already mentioned at the outset, his limited prayer is that the matter may be remanded back to the respondent authority, more specifically the Commissioner of Education, for considering the case of the petitioners herein on similar lines and pass necessary orders upon verification. The Learned Standing Council Education Department fairly submits that such a course of action can indeed be adopted. And without going into the merits of the matter, this writ petition can be disposed of with a direction to the respondent to consider the case of the petitioners on similar lines. And if upon verification, their case is found to be meritorious on the lines of the on the lines of the other persons indicated, they will be entitled to the benefits as per law, right?
Well,
as per law. Upon perusing the materials and giving my consideration to the matter, this court is also agreeable to dispose of the writ petition on the suggested lines by both the learned councils accordingly. Now you can, what kind of direction the respondent number, which is the respondents,
one minute, more particular.
One.
Commission.
the respondent number 1. Will you submit an application before him, or he can consider straight away? No need. Representation is already pending.
Based on material available.
Yes.
They can be
The-
verified.
The respondent number 1 being the Learned Commissioner and Secretary, Education, Government of Arunachal Pradesh, shall take up for consideration the case of the 188 writ petitioners hearing and conduct the necessary verification regarding the nature of their appointment, and based on the outcome of such a process, pass necessary orders as per law. Oh, okay. This will do, I think. For this purpose, the writ petitioners, the writ petitioners will submit a copy of this order before the learned respondent authority, being the Commissioner of Education. The writ petition stands disposed of on the aforesaid lines. Needless to say that if the decision and dispose of the case of the petitioner by a speaking order. Needless to say that upon such consideration and order, if the petitioners are have any further grievances, they will be at liberty to invoke the provision, the options provided by law. That's just not necessary, but still.
Two writ petition Lordship has mentioned, that is 28 November 2023 and 29 November 2023. Two representations.
Or similar orders will pass. No.
No, madam. In Lordship has mentioned in that madam, representation dated.
Or two representations. Yes, two representations of the same date.
No, madam.
Different dates.
One is 28 November 2023 and second is 29 November 2023. Two board representation.
Fine, we've covered.
Much of it.
Item number 15.
My lord, here I am petitioner. So I need one more time to file affidavit and reply. Yes.
Readings are not complete.
My lord, we have already filed a affidavit, and again he is going to file it. So
You filed
short time, sometimes 7 days, within a week he's filed.
you have filed affidavit in
Already
opposition?
filed. Yes. We are respondent Rajiv Gandhi University.
No, I mean, they would be at liberty to file a reply, but of course, within a reasonable time. Right?
Yes.
You are representing all the
Raji, yes, Rajiv Gandhi University.
third petition, Learned Council for the petitioner. Your standing council or?
Yeah.
For the standing council, which department?
Rajiv Gandhi University, Central University.
Oh, standing council represents all the three implemented respondents. And it is submitted that affidavit in opposition have been filed on behalf of all the three respondents. The petitioner side seeks to file an affidavit in reply. How much time you want? So,
Short that may be given.
don't be so harsh also. No, but don't take too much time.
2 weeks maybe.
It's an old matter.
Yes.
Before 2 weeks.
No.
Not happy.
Only, earlier occasion he sick 2 weeks. I allow him.
Very strict.
Petitioner engaged in their marriage ceremony of a elder sister due to busyness.
Lordship, they are stay, unnecessary stay because we have to recruit the assistant registrar.
Oh,
of the
so there's an
university.
order of stay.
Yeah.
The learned standing council submits that a short time may be given for the remaining pleading of the petitioner, as there is an order of stay due to which one recruitment process is stalled.
It's stalled.
10 days? 10 days.
7 days.
I'm not bargaining between you.
Okay, Lordship.
So trying to make both of you happy actually. 10 days, list after 10 days.
Lordship.
Because some wedding in the family is a genuine reason.
Lordship.
Anyway, kindly, file the affidavit. If it's within 10 days, you find, then it will go for hearing or whatever. List the matter after 10 days. It will remain at admission column or should we post it for hearing?
Fix that may be given. Lordship. Fix that.
10 days, after 10 days, we give a fixed date. 7 to 17, Monday.
Something like this.
Okay.
No problem.
Item number 18.
May I please, your lordship. My lord, matter is regarding pending bill.
Okay.
In respect of 5 works under PWD, I had completed, the details are given here, lordship.
Okay.
And they did not pay me the bill. And I have sent legal notices. In 2014, there was a part payment. Thereafter, there was no payment. They have filed affidavit. In the affidavits, they have admitted everything, lordship.
It's all liabilities are admitted.
It is admitted. So, lordship, I feel we need not go any further.
They
It can be
appear.
disposed of
Yeah, you can.
after some time if,
After.
yes.
What is the judgment of our High Court? So recently I had.
There is, there are,
Many, there's one PWD decision, right? It's not. it's not
yes, Food and Supplies Department, which is regarding this Itanagar bench.
Quran Valley, Ali or something.
Yes,
It's like PWD matter. It's not very, it's not recent matter, old.
yes. Recent one we
full
have
bench
to
decision.
24 lordship.
Oh, that's a full bench decision.
Yes. All right.
Item number 19. Yes, bail hearing. It is here. Item number 19. After some time. Item number 20. 20, no petitioner's council name is shown. Yes, you are appealing for the petitioner?
Yes.
Yes. No, name is not reflected.
Last update of my already submitted.
Okay, acha, argument. Case there. Let this Miss Hage come. With the case there. So after some time.
21 and 22 also bail matter also.
Nobody is there?
Nobody, PP is not there.
Maybe he's busy with another court. But 21, your matter? Okay.
He's not there.
Let us wait, together. I think maybe she's busy. Kindly inform her. If she's free, she can come. Or maybe she's in another court. But today, I think, oh,
Item number 23 and 24.
My lord, can you give me some minutes? My son
Busy?
is outside.
Okay.
Yes.
Should we take up this one or this matter or your matter we can take? To some time. I think petitioner is not here. Not just 21.
Item number 19.
AB Lodge.
जहाँ पे petitioner है ना उनको blood matters. Petitioner जहाँ पे है ना, we
No,
can
sir.
call back.
May I know?
21, sir is waiting. Come, sir. We can take up his other petitioners are not here. So we take up later. He's there, so take up.
Item number 20.
21, I think this matters.
He's there.
Oh, I see. Sorry. Please come out. Sorry. He's on interim and he said the arguments were made. CD has been received.
No, sir, CD has received, proceed.
Okay.
What
is the allegation?
The applicant has appeared before the IO and recorded his statement.
Financial dispute.
Yes, Lord.
Financial dispute. No, that is impersonation allegation.
Yes.
Then there could be criminal element also, despite being a financial transaction. Okay. So any case, he has appeared.
He appeared, Lord, and he complied with the condition, Lord.
He's already on interim.
Yes, sir. He may not be required to in the
Yes.
study, Lord, sir.
July, 2210, first two paragraphs are saying. You're Mr. Dewry. On behalf of, your good name, please. And that on behalf of, you heard so and so. Presenting leading counsel SK. Dewry. Stop. The incident case arose out of an FIR dated 24/8/2025. Gist of the allegations is that the petitioner, representing him to be owner of one excavator, entered into an agreement for the same, whereby he received 18 lakhs. And later the alleged victim came to know that the said equipment belonged to someone else. Right, order dated 22/10/2025, the petitioner was granted interim pre-arrest bail. Heard learned additional people, El Hage, who submits. The petitioner is not Keshav Gogoi. He is Keshav Gogoi. Oh, sorry, Raju Boroi. One Keshav Gogoi, you write like that, huh? One Keshav Gogoi. The present petitioner is not named in the FIR. Stop. You write that. He was granted interim and so and so. It is submitted by the learned prosecution that case study has been received and pursuant to grant of interim, the petitioner has rendered cooperation to the investigation and has appeared before the IO
Now, sir, we can have scheduled the case statement.
and has any statement has also been recorded. The case diary has been produced before me. I also feel it's can be I'll have a look. Peruse the relevant portion of the case diary. I've also perused the statement of the present petitioner. He's not a right petitioner, huh? He's not accused actually. In the circumstances, I do not need it, deem it necessary to cancel the interim bail. And therefore, the interim bail dated so and so is hereby made absent, subject to the condition that the petitioner shall cooperate with the process of law,
Earlier condition may impose lordship.
subject to the same terms and conditions. No, because earlier condition was appearing before the IO. I think one of the conditions to that. Shall cooperate with remaining investigation and shall not hamper or tamper with it.
Yes.
That will do. Return back the case diary.
Much obliged.
Item number 21.
Lordship, we have not received the case diary in the item number
Yes, madam.
21. Yes, Lordship.
Maybe, huh? Is an
Yes, sir.
interim is there?
Yes, interim already granted.
Extended.
Yes, Lordship.
Uh, again, learned additional PP submits that case diary has not yet been received. Issue fresh requisition / reminder. The interim bail granted, interim prayers bail granted to the petitioner by order dated 27/10/2025 stands extended in the next date of list on
After 2 weeks, Lordship.
after 2 weeks.
So obliged.
Item number 22.
My lord, as per the instruction of this honorable court, I appeared before the IO and the statement has been recorded.
CD received.
What is the allegation? You can also submit from the
115, that is causing voluntarily hurt and arms act.
Oh, this is the judgment.
No,
So CD.
yes, Jerry.
My lord, here in this case, arms act had been registered because the allegation is that this petitioner accused had assaulted the informant victim with the muzzle of the revolver. So my contention to in this regard is, my lordship, that section 27 of arms act will not attract in an incident where the assault is done by revolver, but with the muzzle or its whip.
That's an interesting point.
Yeah, because the section
27 is a very stringent provision.
Yeah,
So well,
For using of the arms.
that is that interpretation may be correct because it's a very stringent provision.
Yes.
Using a firearm,
Yes.
no?
using a
Firing a bullet.
Yes, for firing purpose, but in this case, it was not fired.
It would be a normal assault then.
yes,
maybe.
yes,
115, that is a voluntary causing hurt.
and that is non-cognizable offense, my lord. 115.
Bailable offense.
Yes.
Interim was granted and he appeared before the IO on 30th of this October month. There was
My lord,
interim,
this is a case of FIR and counter FIR, my lord. Because here the, my lord, petitioner accused was was working as assistant engineer, and he was posted from Sonpura to Mahadevpur. And this informant victim is a junior engineer who was holding the charge of assistant engineer. When this assistant engineer, petitioner accused, went to Mahadevpur and joined there and asked for the charge, the informant victim denied. Therefore, a writ petition was filed before this honorable court. And as per the instruction of this honorable court, my lord, instruction was given that the regular assistant engineer may be given the charge. And after passing of this honorable court order, the executive engineer, PHE, issued an order that the charges should be given to this petitioner accused. And because of that order, my lord, this informant victim got aggrieved and he got a...
Aggrieved and angry.
Yes, and they had a...
And they had a tussle.
They had a quarrel,
tussle, and because of that, my lord, this FIR and counter FIR was
He's alleged, any injury report is there? Simple injury.
simple.
Okay. Then allegation is little, exaggeration. It's possible.
And my lord, after that, this writ petition has been also disposed of because this accused petitioner has come back to his ordinary posting place, and the charges still now remain with the informant victim. My lord. So now there is no fighting between these two persons regarding the charge.
Everything is settled. Then.
Yeah, everything is settled.
Actually, there was a couple for a chair posting place.
Okay. So this should also have a happy ending.
Yes.
So let's see. Para 1, 2, 27/10/2025. Para 1, 2, same. It's tough. The petitioner was granted interim pre-arrest bail on 27/10/2025. He is working as an assistant executive,
Assistant engineer.
and the informant is also
He is junior engineer.
the informant is junior engineer. Stop. The case diary has been received. Stop. Pursuant to grant of interim, the petitioner has appeared before the investigating officer, and his statement has been recorded.
Yes,
Right.
on 30th.
Medical report, I'm not up to my notice, but simple injury is there. No? Simple injury. Can I record that submission? That is yeah.
Simply, it may be
I
stated.
found it. It is also revealed from the case diary that the nature of the injury sustained was simple in nature. In the circumstances, the interim bail deserves to be made absolute. Made absolute and the same conditions. Cooperate with remaining investigation, not hamper or temper. Right?
And it may be
Written by the case diary.
CD may be written.
Written.
Deeply obliged.
Obliged also.
Matter number 23 and 24.
My lord, IA 194/2024. This is relating to commission of perjury.
Okay. Just a minute. Let me see the facts once.
My lord, the
Should I take up the IA first?
IA passed.
The IA is only here.
The fact of the matter is that I have a private plot of land at Tama Chung Chung. And in the year 1968, Assam Rifle illegally occupied my land. It was in their possession for a long time. Thereafter, in the year 2004, ITBP took over the land from Assam Rifle, and they are still in possession. Now, they wanted that land with acquisition. For that, I was requested by Deputy Commissioner to give NOC. I have given NOC for 19 acres, madam. The total area of land occupied by the Assam Rifle was 187 acres.
187 acres.
187 acres. And same area of land was taken over by the ITBP. So, for acquisition process, they have started in the office of the Deputy Commissioner. It was assessed for 4 crore some amount. Let us consider it as 4 crore. Then I was expecting that I will be paid the compensation amount. They have delayed the payment. So ultimately, without having no alternative, I approached this court by filing a writ petition, which is still pending, my lord.
And the prayer of the writ petition is compensation
Yes, madam.
for the land which has been taken by Assam Rifles.
Assam Rifle. Earlier Assam Rifle, now
ITBP. Indo-Tibetan.
Now, my lord, yes,
they have filed affidavit before this honorable court.
Hmm.
In their affidavit, your lordship will find at para 5 in their affidavit. It may be ascertained from their affidavit.
I found affidavits.
May,
Which affidavit? Page?
para 5, my lord, in their affidavit.
Page?
Page 3 in their affidavit, in main case, in main case. In affidavit in opposition in writ petition.
In the main case.
In main case. Para 5, my lord.
It's here.
My lord, in IA, I have annexed the affidavit. From IA also. we can
Okay,
accept.
I can see page number.
In IA,
Yeah.
page number 3, page number 35.
Okay.
35.
Yes, I found this affidavit. Yes, you underlined also.
Yes, 35. Page 35 in IA.
Yes, para 5.
Para 5.
Yes, you underlined also.
That with regards to statement made in para 3. That with regard to statement made in para 3 of the writ petition, the deponent states that under reply are matter of facts and Assam Rifle was under occupation of land at TCC means Tamachungchung. And after that, ITBP took the possession of the land at TCC, but the same is never demarcated by the concerned authority. One issue is never demarcated. That will be proved later. I'll find it out now. Hence, it is incorrect to say that the whole 187 acre of the land is under direct possession of the Assam Rifle and ITBP thereafter from 2004. Here also 87 that has been mentioned, and it says it was never under possession of ITBP, but it was under possession. Still, it is under their possession. I'll prove it later. Now, my lord, kindly turn to page number 41.
41.
41. In the IA, para 17. Para 17. That the deponent respectfully submit that the instant writ petition is based on imperfect, unauthenticated, wrong, and misleading outcome of chain compass survey, which has not been accepted by the respondent 1, 2, and 3. Hence, the petition is liable to be dismissed with cost. Here it says the authority did not accept the assessment made by, it says, unauthenticated, wrong, misleading outcome of the chain compass. The instrument used was chain compass.
Chain compass, it's a matter of survey.
It is matter of survey, but they have given false information. In fact, it was accepted and PAN was sanctioned. We'll come to all these points one by one. Let's see page number 44. Page number 44.
What is the prayer in the IA? It has come for?
IA is for initiating proceeding against the these deponents. Deponents means respondent number 1, 2, 3, and 6
For
for
this
giving
affidavit.
false information.
For this affidavit. For this affidavit.
Yes, yes. They have,
Factual,
given-
factual, okay.
they have given false information before this honorable court, that too by affidavit. So they have committed the offense of perjury, my lord. Now, page number 44, my lord. Page number 44, subject says, survey of land for ITBP campuses in Upper Subansiri district of Arunachal Pradesh.
Page?
Page 44, in IA, my lord.
Yes, I'm here only.
My lord, let us see para 3.
We'll just see that and then we'll resume. That's the phone request. It's personal. Okay. Look into the case personally.
Yes, para 3, my lord, there is a one table.
Yes, stay. That's what I'm.
Serial number 1. TCC, Tamachungchung, area has been mentioned as 187. Now, it is very clear that they have, they are in possession of 187 acre. But in the affidavit, they have said that 187 acre is not in their possession. This is a perjury, my lord. This letter is written to the deputy commissioner by the ITBP officer, commandant.
Anyway, we'll resume.
May I, Your Lordship? Your Lordship,
We'll resume after lunch.
After lunch.
Your Lordship, I'm appearing for a state respondent.
Yes, yes.
Here, the SBI, he is the main party, and he is absent today. I say.
They must have filed a reply to this, this
They have
contention about perjury, right?
They have filed.
So we'll have to. We'll
There is an order.
You are not. Yeah.
Regarding the main petition also, like, Your Lordship, conducting counsel is Miss G. She is absent today. She is having some personal difficulty.
Okay.
My lord, Mr. Kato was present here. He has argued before this honorable court earlier. And I think he might be thinking that matter will not come soon. So
Okay.
he has.
No problem.
Let us resume after
I'll
two.
also, go
Let us
through the
resume after
IA pleadings in between some
After
time,
two.
and we'll resume at 2.
Yes, my lord.
Have your
Yes.
lunch also.
Yes.
My lord. Sign some orders. And then the IA can be, I mean, of course, the council has to be there. Otherwise, the writ petition is at the stage of.
I'm not there in the IA.
You're not there. Okay.
My lord, shall I continue?
Yes.
My lord, we were at page number 30. At para 5,
Page number 30.
2020 in IA.
Yes. 20 IA.
In their affidavit at para 5, they say that they are not in occupation of 187 acre. But as per this document, page number 20.
No, this was page 45. Oh, sorry, not this one.
20.
Not this one. That Assam Rifles document.
Yes, sir, in
you
my
mentioned.
IA, my lord.
Yes, I just saw it. Just now, I was reading the file.
My lord, would you lock it?
Yes. 44.
In my IA, it is 20.
This,
Sorry, sorry. Yes, yes, yes.
This is order dated 1410. Right? This is the one?
1410.
Okay.
To the deputy.
To the Deputy Commissioner, Upper Subansiri District.
Yes, yes. This letter is written by Commandant.
Commandant.
Then
ITBP.
Yes, ma'am. As per this document, they are in occupation of 187 acre at TCC. But They have said in para 5, they are not in occupation of 187.
Let us read the para 2 of this letter in this regard.
Yes, ma'am.
Reference.
In this regard also,
Reference.
reference discussion held with second in command of this unit with your good self on 21/9/15 in your chamber. During the meeting, decision was taken on the subject that survey will be conducted in the month of October 2015. But after lapse of half month, no any action taken or scheduled to be taken by your office has not been received till then. Higher HQRs of ITBP is pressing her to liaise with your good office and finalize the transfer/allotment cases of land held physically by ITBP in Upper Subansiri district for Arunachal Pradesh. Para 3. It is therefore once again requested your good office self to look into the case personally, initiate the survey process at the following 4 locations in favor of 10 ITBP. Here it says in 4 locations. The relevant location is at serial number 1. TCC in area under position 187. So this is a clear case of giving false information before this honorable court, my lord.
Okay, they are saying I just no problem. Yeah. Collect, yes, you can connect. You have to just pause, just for two minutes.
All right.
There's one DB judgment to be pronounced.
All right.
Justice Devasis is joining from.
All right.
I have joined from.
All right.
He's sitting there. Yes. Just, no, he's pronounced, no problem. I had given the authorization actually. So we can continue.
Shall I continue, my lord?
Yes, please.
Well, let's see the next.
What I was saying is that when I went through the affidavit, I mean, prima facie, of course, they must have filed their take on this matter.
Yes.
That they are saying that it is not in complete occupation. This is what they are saying. But whether it is anyway, going to it. So according to this document, according to your interpretation of this document, is that 187 acres.
Yes, 187 is another.
And they are pressing for the settlement.
Yes. Now let us see the next page, madam. This is letter dated 8/9/2017. Sorry, I. Next letter, 8/9/2017. Let's see para 2, my lord. In the subject letter, the measure of TC post has been mentioned at 1.87 acre, which is grossly wrong and far less than the land size handed over to ITBP by AR on paper, 187 acres. My lord, this letter was written by Commandant 10 BN ITBP to the Deputy Commissioner. Deputy Commissioner.
This letter, no? This
letter clarified that the Deputy Commissioner has sent a letter to the Land Department. In that letter, 1.87 was mentioned, and that has been clarified by this letter. It is not 1.87, but 187 acres.
Yeah, one.
So this also shows that 187 acre is in their possession. And as per para 5 of their affidavit, whatever they have stated in para 5, it becomes false, my lord. Now, next page, 46. Last paragraph, page number 46, annexure 5 in my IA.
Oh, and just, what is the stage of the writ petition? Louis?
Actually, this writ
If you
petition,
remember.
they have filed affidavit. It is ready for final hearing.
You have filed reply.
No, no.
No. Pleadings are complete, ready for hearing.
Completely. My lord, the last paragraph, page number 46. There was long pending issue of redemarcation of aforementioned land for which ITBP has been requesting since long for press demarcation so as to initiate the process of acquisition of land. The unit is so grateful for your kind cooperation and timely action taken in this regard. As the demarcation has been completed, but the next course of action regarding notification is still pending, which needs to be expedited by the concerned department. This also proves that the statement made in paragraph 5 in their affidavit is false, because they have said, but same is never demarcated by the concerned authority. Never demarcated. But here they are expressing their gratitudeness that the demarcation has been made. For that, they have extended their gratitudeness to the deputy commissioner. So this has also become false, which is punishable offense under law. Next, my lord, at para 17.
17 of?
In their affidavit. In their affidavit, it is.
You have annexed in your IA, right? You have annexed?
In their affidavit, page number 9, in my
17.
IA,
I'll find it.
in my IA, it is 41, page number 41.
Yes, yes, I found it.
Para 7.
Chain compass survey.
Yes, yes, chain compass survey, that issue. It says that the deponent respectfully submits that the instant writ petition is based on imperfect, unauthenticated, wrong and misleading outcome of chain compass survey, which has not been accepted by the respondent number 1, 2, and 3. It says chain compass survey was used and that has not been accepted by the authority. But as per this letter dated 8/7/2021, which is at page number 48. Here, PAN has been sanctioned. PAN has been sanctioned on the basis of the survey made by using compass survey method. So the statement that it was not accepted by authority, that becomes false, my lord. Because accepting the assessment made by using compass survey, the authorities accepted it and PAN has been sanctioned. PAN is 4 crore 88 lakhs, no, 4 crore 88 lakhs 2,987. It is mentioned in last column.
Yes. What is the relevant provisions of BNS you are?
I'll come to that, my lord.
Just want to have the.
This application has been filed under section 379, read with section 215 of BNSS, my lord. And the offense is punishable under section 229.
That's it. I have 200.
29, 229 of BNS. It is corresponding to 193 IPC.
IPC.
Yes, my lord.
Mm-hmm.
229, punishment for false evidence.
These contents are same. These provisions have not been changed. That is.
Not changed,
Only the number.
only the number. 193 IPC corresponding to 229 BNS.
Okay.
My lord, in a similarly situated circumstance of the case, the Honorable Supreme Court has passed an order directing the registry to register a case against the respondent.
No, first the court has to be convinced that it is a false statement. Right?
No, she is not
No,
party.
she's not. The
in
court
the
has to
IAS.
be convinced that it is a false statement, right?
Hmm.
So it has to be proved to be a false statement to the satisfaction of the court.
Yes.
Then that the question of criminal prosecution arises. Okay. So now
My lord, the
193 earlier, now that new provision.
yes, 229.
Mhm. Whether you wanted to yeah, you were mentioning about the Supreme Court.
Before that, my lord, there is an order of this honorable court.
This is the last order actually.
Last
Yeah, let
order,
us read this order. No?
3/6,
Yeah, this.
2025.
Let us read this order.
Yes, my lord. Hard Mr. S. Koyang, learned counsel for the applicant petitioner. Also hard Mr. M. Kato, learned deputy SGI for the respondent number 1 to 3 and 6, as well as Ms. P. Sangita, learned government advocate for the state respondent number 4 and 5. Next para. During the course of hearing, Mr. Koyang, learned counsel for the applicant petitioner, has drawn the attention of this court to page number 44 and 45 of the interlocutory application, which are the letters dated 14/10/2025 and 8/9/2017, written by Commandant 10 BN ITBP Police to the Deputy Commissioner, Upper Subansri Dapurijo, and submits that in the aforementioned two letters dated 14/10/2015 and 8/9/2017, the respondent number 3 had admitted the land under their possession is 187 acres. But in their affidavit at paragraph number 5, the respondent number 1 to 3 and 6 had taken a stand that it is incorrect to say that the ITBP took possession of the land at TCC measuring 187 acres of land, which was under the direct possession of the Assam
Yeah, this will require an explanation. You know why they say so.
Yes,
If it is a question of interpretation, then the per se directly may not be
this
pertinent.
is just an
But if
observation.
it is just in suppose it is proved that at one place it has been said that A is B, and another place it's been said B is A, then obviously that's something like that.
This is just an
But if
observation.
it's a
of
question
this,
of interpretation,
this is just an observation of this honorable court.
yes.
Then shall I skip this? But my lord, the last
This is the
paragraph.
last operative order actually.
Last paragraph. No, last paragraph means in the page number 4. At this stage, actually instruction was given to take. Direction was given to take instruction to Mr. Kato. It is at Yes. Last bit, taking note of the submission of learned counsel for both the parties, Mr. Kato learned, Deputy SGI is allowed to obtain necessary instruction from mentioned respondents and apprise this court of the same on so and so.
So Mr. Kato is not here.
He is not there, but this is unfortunate.
No, because we'll have to, hear him also, right?
But
To hear him.
this is unfortunate that he has argued in item number 13 in the morning shift.
So anyway,
And
you call him then if he's around. I mean, you can send your junior to inform.
then
Because otherwise, because I mean, I have now understood the matter, but beyond that point, it will be, since he's not there, it will be have to, because it is pending for instructions. Actually, first we should have got that instructions. But it was, the matter was new to me, so this was, your submissions have helped me to know the matter.
Yes.
Right. So
Yes,
know the matter.
my lord, this
It has not gone in vain. I have understood the matter.
this is in fact.
So now this interpretation is there that that what is the stand in the affidavit that where they have stated that is not completely in occupation. Does it really go contrary to another factual does it amount to stating a wrong fact, factually incorrect thing? So this is the thing. So
My lord, can we have Passover for timing then?
we can pass over for the time, and let's see. Otherwise, we'll have to fix it for say
My lord, this is pending matter since 2003.
pass over and fix it for Monday or Tuesday.
No,
Monday or
In any case, I would not like to complete the hearing. Even if he appears, I would not like to. Even if he appears, I would, considering the nature of the matter, I would like to do it in 2 installments. Suppose he was there, we complete the hearing. Tomorrow, day after, I study it properly. Then again, the remaining part, I do it on review. Then I'll be in a better position to appreciate. So for the moment, let us wait. Time being.
otherwise, my lord,
You can seek him out and
Okay.
ask him.
okay, let me try to. call him.
Otherwise, then you come back. Thereafter, we'll if it doesn't work out, we'll fix a date.
Okay, let me try to call him.
You can contact him.
Matter number 25. Obligement.
25. Order.
May I please?
Mhm.
My lord, this IA application
Hmm.
for modification and recalling of the withdrawal order passed by December court, because earlier writ petition was filed, but it was not purposefully served. So I would like to read the order passed by December court, earlier writ petition. Page,
You're for the applicant petitioner.
yes, I am applicant petitioner.
Ma'am is appearing for the respondent.
Page number 13 is the order passed by December court. I would like to rely page number 13 of my application, last para. Sri Majumdar Learned Council, General Council submit that the petitioners are in possession of the land in question for the past 3 generations, and pursuant to communication dated so and so, the LPC were granted. Then second para, after hearing the party, this court is of the view that petitioner have approached this court after a considerable delay, and accordingly no blanket order of stay is called for. However, it is made clear that since the cancellation is on the only ground that the land in question is under reserve forest, no third party would be allowed to occupy the said land. The authority are also directed to consider a prayer of the petitioner for possession of the land till the disposal of this writ petition, for which the petitioners are directed to submit necessary application before the concerned deputy commissioner. In case the application of the petitioner are favorably considered, it is further made clear that petitioners shall not carry out any activity over the said land which may be detrimental to the forest. On the basis of this order passed by the Honorable Court, the petitioner applicant submitted the application before the Deputy Commissioner UPIA. That is next page number Annex B, page number 15. And this application I submitted before the concerned authority, and on the basis of this application submitted by the petitioner, the learned deputy commissioner
Against the
passed an
cancellation.
order.
Against the cancellation.
Yes.
Right?
After submission of this order, my LPC cancellation is revoked for a temporary period. My LPC 8 numbers of LPC were temporarily revoked. And on the way, after submission of my application, this is a revocation order, page number 19.
Yes, yes, I'm on
Yes.
that. In disposal of the writ petition. Correcting the first of all, to consider the position. Okay.
And after passing of this order,
Huh.
the learned deputy commissioner UPIA issued us and approached us to withdraw the pending repetition, and they issued us to regularize the LPC. After
That,
assurance,
the
on
inter-
assurance of
This interim order was there, given that it will be revoked till the pendency of the writ
Pendency of
petition. And then there was an assurance that you withdraw the writ petition.
then
but
they
it
issued
will
to
be done.
withdraw, they also issued to regularize the LPC, and I was asked to withdraw. Accordingly, I was withdrawn the application before this Honorable Court. And what happened after withdrawal of the application? That person, deputy commissioner, was transferred to some other place, and another deputy commissioner come. But it was new to them. Therefore, the present deputy commissioner refused to regularize my application. So my
Actually,
withdrawal application.
withdrawals and all on verbal, assurances always. There.
So that
Administrative matters always proceed on written communication.
withdrawing.
So now
I was not
that
granted liberty.
Mhm.
So this is only praying for granting the liberty to file a press, because earlier writ petition I purpose not served.
Mhm.
So for the
that writ petition was withdrawn without liberty.
without liberty. So therefore, it was withdraw liberty not there.
But
So-
this IA, okay. Achha.
So the next 24.
Or the writ petition, disposed of. Fine.
Disposed.
And
This
it will be IA or review? Review.
Your Lordship. And in the order also, Your Lordship, while this IA was filed for withdrawal, he has received the instruction from the petitioner for withdrawal, Your Lordship. And in the order passed by the DC also.
Can
Your
we see that order?
Yes.
Can we see the order in the disposed of writ petition? Let us see the words. It is here, I think, annexed. The schedule. Instructions.
Page 14.
So, as I understand from your contentions that you feel laid down. I'm not using the word cheated, but you feel laid down because there was an assurance.
The
Anyway,
DC why not transferred to some other place, then definitely it could purpose.
this time repetition stands disposed of on withdrawal. Yes.
But in the DC's order also, it is revoked till final disposal of the writ petition, Your Lordship. Whether he has assured him or not, Your Lordship. Because with the instruction from the petitioner, he has withdrawn the
That's
writ
true.
petition, Your Lordship.
If the word with liberty to file a fresh one is not mentioned,
Yes.
it will bar.
Whether.
Really, SGI was to obtain necessary instructions for appraisal of this court. As the same is not presented today due to the absence of the learned standing counsel, therefore close the matter after 2 weeks. Please the matter after two weeks along with the main writ petition.
Yes.
Okay.
Obliged.
Matter number 18. I think 18. Time. No bail, two bails also there. Yes, please, ma'am.
May I please, your lordship?
Please.
My lord.
Bills.
Yes, bills. My claim, my lord, is mentioned in paragraph 13, my lord, of my petition. The total comes up to 97 crores. So this is of four different works, my lord. Construction. Para 13, page 8. This is those amount pending dues along with interest accrued up to December 2024. I have, my lord, several times approached the respondents. My last legal notice was on 13/1/2025. This is at page 30. Then, my lord, in reply to this, your lordship will see at page 58. In reply to my legal notice, they are saying, may I read, your lordship? Page 58. This is by the Executive Engineer, Doimuk Division, PWD. This is to my counsel, saying that, while referring to the above mentioned subject, it is to inform you that in spite of several correspondence, we are not able to manage funds for release of your pending bills. The chief engineer by letter so-and-so dated 17/8/2022 and number so-and-so dated 17/1/2023 had requested the executive engineer PWD Doimuk Division to settle the issue at division level. But due to non-placement of fund for clearance of your pending liabilities of your client, payment could not be released so far. Payment of pending bills shall be released as and when fund and LOC is received from the competent authorities. This is in reply to my latest legal notice. Then page 59 and 60 are, my lord, written by the executive engineer to the chief engineer.
This also constitutes partly, but you have mentioned in the earlier hearing we have taken. Who is the admission, the specific?
Yes, the admission, lordship. The admission in there, my lord, affidavit in opposition.
File an affidavit.
Yes. My lord will see page 63, para 8. This is filed by the respondent number 5, the executive engineer.
Page 63.
Page 63, para 8. Para 8, as my lordship found. With regard to with regard to the statement made in para 8 of the writ petition, the answering deponent begs to state that the respondent has received several representations from the petitioner for payment of pending bills for 4 projects mentioned in this writ petition. On receipt of representation from the petitioner, white number so-and-so dated 8/8/2022, the chief engineer respondently directed executive engineer Doimuk Division to settle the issue at divisional level by correspondence number so-and-so dated 17/8/2022. However, due to non-availability of funds, the issue could not be settled at the division level till now. Then your lordship will see in the same page, page 68, para 10. Here also, lordship, the answering deponent with regard to the averment made in paragraph 10 of the writ petition.
Which para? No?
Para 10, same page, page 64.
Answer begs to state that.
Yes.
Receipt of representation.
Receipt of representation dated 30/12/2022 the chief engineer, respondent 3, directed executive engineer to settle the issue at divisional level. However, due to non-availability of funds, the issue could not be settled at division level till now. Then, Your Lordship, I have mentioned in para 13, I have given the details. With regard to this, in page 65, with regard to the, in answer to this, Lordship, we'll see at page 65. In paragraph 13 of my writ petition, I have given the details of how much they are supposed to give me. Then in reply to that,
Okay.
yeah, in reply,
Para.
para 13, here also para 13,
Okay.
page 65. With regard to the statement made in paragraph 13 of the writ petition, the answering the opponent begs to state that due to non-allocation of fund for the petitioner, pending bills could not be paid. Payment will depend on availability of fund. So basically what they are saying, funds are not available. They are not saying that we are not liable to pay, just that the funds are not available. So my lord, the writ petition may be disposed of in terms of this, saying that they may examine the issue and then pay as with respect to the four works.
Yeah, government.
As stated in our affidavit, Your Lordship, it is due to
That
non-availability
is
of
a
fund.
big
Your
problem nowadays anyway, but obviously, someone has executed the work,
amount, Your
will
Lordship.
obviously come to ask for the money. Yeah.
Yes, Your Lordship. Exact amount, Your Lordship, has not been examined yet, Your Lordship. So the letter from the chief engineer to the executive engineer has clearly requested the executive engineer to examine the pending bills and then to consider saying that. So since no fund is not there, Your Lordship, that is the reason, Your Lordship, you could not be settled, Your Lordship.
But liability is admitted.
Yes.
It is admitted. According to her, it is admitted, but
They have admitted the liability in the affidavit in opposition as well as in the reply to the legal notice also.
because examination of the issue, obviously, it is always subject to availability, but examination of the issue does not necessarily mean, that admission. If
Yes.
the liability is examined, then also it will require some,
Yes.
the examination, because the basic things have to be verified.
Yes.
The work orders have to be tallied. All
Yes.
these things have to be done, even if it is admitted.
Yes.
But if the liability is not admitted, then per se, the writ jurisdiction
Will not lie.
fails, the disputed fact.
Yes.
So that is our law,
Yes.
as a full bench decision,
Yes,
which I was mentioned in the context of PWD in Assam.
Yes.
So I would like to see, whether there is any more clearer document apart from this regarding the admittability. Your affidavit also must be, throwing some light on it. Because if there's no dispute about fund crisis, it's okay. It's okay.
In paragraph.
That is everywhere nowadays. But if the work, execution of the work and the amount liable to be paid is not disputed, then perhaps something can be thought of.
In paragraph 11 also, Your Lordship.
Of the affidavit,
Yes, yes.
can we see your?
Page 65.
This you had shown me this now.
Yeah, due to non-allocation of fund for the purpose, pending bills of the petitioner could not be paid. Let us see.
Even if we direct that they will examine,
Yes.
but will it serve a purpose? Subject examine, then again they may say there are no funds. No, authority may say.
Sure.
Your response can say no fund. These are state financed or central funding?
State fund.
State funds. With central funding, then of course. you can
Lordship
al-
may see page 16. This is a correspondence.
Page 16.
Yes, page 16. To the chief engineer, design and planning. From the chief engineer, Western Zone, page 16, annexure 1.
Mhm.
This is talking about the pending bills. In serial number 1, serial number
How many bills you have mentioned in the writ petition?
4.
4 bills.
Yes.
And these are the 4 bills.
Yes,
These are-
no, this is including the 4 bills. This is, in this letter has been written saying number of letter received from MS Tama Fabrication regarding clearance of pending bills, copies of which are enclosed for your further action, please. Details of the pending bill of name of the works are below, produced below. You are requested to keep necessary provision to clear the above liabilities by including proposals in the AOP during 2013-14. Please, meanwhile, concerned EEs and SCs have been asked for detailed exam and submit reports on the subject and the actual pending thereof. This, it is from serial number 1 to 7. Among these, serial number 1, then serial number 4, then serial number 7, and serial number 5.
These are your works.
Yes, all these are my work, but so far as this writ petition is concerned.
Yes.
Yes. Then the same thing, Lordship, additional allocation was done in the next page. This is 24 December 2013. Here also, Lordship, some part payment was made by this allocation. So it is very clear that they have admitted that there are pending bills. Lordship.
Otherwise, Your Lordship, I have filed on behalf of respondent number 5 only, Your Lordship. From other respondents, Your Lordship.
Who's representing?
Commissioner PWD, Chief Engineer. Respondent number 2, 3,
Let us see that.
2 and 3, Your Lordship.
Respondent number 5 is?
5 is the executive engineer.
Okay, he's one of the authority. It has the chief engineer had directed the executive engineer to examine.
Yes, Your Lordship.
Examine.
Yes.
And you filed the affidavit that fund, due to fund, non-availability of fund.
Yes, that is the,
That could not be exercised. That process, that exercise could not be conducted.
yes.
And PWD council is, standing council is there?
No,
No,
Lordship.
competent.
Yes, representing all.
Let us, I think, there's not much actually to either. What can you do? I can give a direction since it is admitted, but again, it will remain stuck in fund crisis. Even they can pay in installments if it is, no, that's, one has to be reasonable also.
Lordship.
But I don't know, but PWD, I think it will be a higher authority of PWD. Maybe it may be helpful to,
Yes.
you know,
Yeah, I filed on.
see what they have to say.
Lordship.
And they have also filed an affidavit.
No, no,
They have not filed.
they have not filed.
Heard counsel for the,
And Duncan.
yes, for the writ petitioner. Ma'am, for the, your government,
Yes,
for the respond number 5. You just write, for this, within bracket, executive engineer PWD, Doimuk division. First, 5 respondents have been implemented. And the remaining respondents are the respondent number 1 is the Chief Secretary, Government of Arunachal, and the respondent number 2, 3, and 4 are the Commissioner, Chief Engineer, West Zone, and Superintending Engineer, West Zone, PWD. They are represented in this case by the learned. Who's the government advocate who's appearing here? Name? Government advocate?
yes, I'm appearing, Your Lordship.
No, 1, 2, 3, 4.
For them also, I'm appearing.
Also, you also
Yes.
for that. Sorry, I thought you were only for 5.
No, for all of them.
Appearing for all the respondents. However, it is fairly submitted by the learned government advocate that affidavit in opposition has already only been filed on behalf of the respondent number 5. The petitioner has invoked. Then there's no point. I mean, you can represent all of them.
Yes, Your Lordship.
There's nothing.
Since I have not received instruction from the other.
Then that you can do.
Yes,
The petitioner has invoked the writ jurisdiction of this court under Article 226 of the Constitution, seeking a writ / direction to the respondent, specifically the respondent number 5, to clear 4 contractual bills, 4 public contractual bills of the petitioner amounting to rupees 97 crores 60 lakhs 92,414.87, right?
Yes, madam.
Amount is correct. Sister. In a nutshell, it is the contention of the petitioner is that the petitioner firm had executed 4 works on behalf of the PWD and giving rise to the bills totaling the aforesaid amount. Drawing attention to a later communication, official communication dated 31/7/2013, within bracket, Annexa 1, available at page 16. The learned counsel submits that by the said letter, the liability, these are not the total liabilities, no? 3.25, 6.2.
No, no, no.
These are
This
part
was at that
liabilities.
time, Lord Sir. This was at that time, Lord Sir, 2013. This is only to show that this was admitted then also.
Then you cut the last line. It is contended by the petitioner side that the 4 bills totaling the aforesaid amount pertaining to the works undertaken by the petitioner firm have been admitted, are constitute admitted liability of the department, and it has also been contended in the affidavit that the executive engineer PWD, that division, slash respond number 5, was directed by the chief engineer of the department to examine the examine, what is the word used?
To examine
The pending bill.
Examine the pending bills
Liabilities.
of the petitioner
and settle the issue at your
and
end.
settle the issue, but the executive engineer PWD respondent 5, right, letter dated 27/1/2025, stated that the payment could not be released due to non-placement of funds. In this backdrop, it is contended by the learned petitioner counsel that there is no dispute about the bill amounts and being admitted liability of the state through the PWD department. Through the PWD, she is invoking, the petitioner firm is invoking the jurisdiction of this court, seeking a direction, as the payments have not been made. The petitioner counsel has also drawn the attention of this court to the affidavit in opposition filed by the respondent, wherein such difficulties of funds have been mentioned. The learned government advocates, the learned government advocate representing the respondents submit that. Can I record that due to the fund problem?
Yes, it is in the affidavit, Your Lordship.
No, that as stated in the affidavit, due to fund crisis, it has not been possible to make the payment. However, the learned government advocate submits that she would like to take some further instructions from the other respondents, especially respondent number 2 to 4. 2 to 4. Regarding the prayer of the petitioner side for disposal of the writ petition with a direction to make the payments. This will be okay. Another court also can refer if it comes before. This is the matter.
2 weeks, Lordship.
2 weeks.
Okay.
You can check up. You must be knowing, madam, that judgment. I forgot the name actually. I had discussed in past an order in Nagaland, September. A full bench decision of a high court. I think PWD matter. This admitted level is a constitutional. It comes from the Supreme Court law also. But in the context of Northeast, this was a detailed judgment which we can have a fresh look to understand both the department and especially the department. If the liability is actually there, it is no dispute about the liability, then it is very difficult to, say that payment will not be made. But the fund problem, again, how to resolve this kind of thing. But obviously, there will be a petitioner who undertakes a work and not being paid. Definitely, the petitioner will be aggrieved. And if that is not disputed, then definitely money might have spent money from their side in the work. So they will expect and therefore they come for this court. But again, how to do this? Because just giving if really there is no money, then just giving a direction also again will lead to a contempt petition. So if something can be worked out, once, that's why higher authorities may be able to help if they can talk with the finance and get funds. Okay.
No.
List after 2 weeks.
Item number 26.
26. None appears. So on consideration. The contractual matter. None appears on behalf of the petitioner on call. List the matter after. This not just, there might be some. Here is the order dated 18/6/2025. You just refer to this order. Pending for service. None appears, that will be there. Huh? But as per office note dated 6/11/25, service is complete upon respond number 4, but awaited with regard to R5, respond number 5. The order dated 18/6/25 also reveals that petitioner was permitted to take dusty service upon respond number 5 also, or also take dusty service also respond number 5, but and file compliance, but there is no reflection in the office note to that effect. Standing Council Rural Development had earlier accepted notice on behalf of respond number 1, 2, 3. So just keep it updated. 5 respondents have been included in the writ petition. Let's stop. The petitioner side shall file compliance of dusty service upon respondent number 5 if any. Full stop. The remaining respondents are at liberty to file their affidavits. In the order dated 18/6/2025, it is mentioned that you just leave this. It's provided that the issuance of supply orders, the last line of the second last paragraph, right? This matter up to 3 weeks. Along with writ petition 268 of 25. Right? Letter number 19.
Lordship, in this heavy metal lordship, they alleged accused that lordship, he have granted bail lordship, but he
Interim
never
bail?
appeared, yes, lordship, he never appeared before the IO for statement, so his on last order that recall lordship,
Mhm.
the interim was recalled.
Okay, it's provided it is updated.
Lordship, he's updated lordship, I have produced on the last occasion, so.
He has not appeared
No lordship, till now he has not
because
appeared.
recording is not in someone's hands, right? The IO may be busy but it's my duty to appear.
Yes, lordship.
But if the IO is busy and suppose he says does not record, it may not be my fault, right? You get my point, no? So, but he
has
should
to
appear.
Appear before.
That's why
yes,
we
lordship.
write now, make himself available for
Yes, lordship.
examination. Right?
That's why lordship to not only once lordship, since 3rd of September 2025 lordship,
Why he is,
till date lordship.
what is the conduct is not
Not lordship.
not good.
Lordship, yes, lordship.
Case diary is received.
Yes, status I have received where
I
it
see.
is clearly reflected that the accused, instead of appearing before the IO in person for deposition of statement, he never turned up neither before the IO or OCPS. But however, what he did, he has contacted over phone to IO. And at that time, the IO was on leave, lordship. And that IO advised him that you go to PS, whoever is in charge of them, he never appeared. Yes, lordship. The conduct is also not that.
19 lakhs loan.
Yes, lordship.
That's what I know.
If he appeared, lordship, that to
Sometimes
not.
I don't know.
Yes,
It
sir.
may not be fair to say that, but anyway, sometimes if suppose we don't know are there any other cases pending against him? Because that could be sometimes what happens that if suppose a person is habitually involved in this kind of activities,
Yes,
suppose
okay.
alleged activities, and the other cases pending, so therefore there will be hesitation that he may be arrested in the other case.
I have not
But
already
still,
proposed.
that is not justification enough.
No, no.
That also you file a bail and seek anticipatory bail, right?
He
Can I
is
have a-
already protected lordship.
Yes.
Yes, no, this is the status. Yes,
That is one of the, he's actually violated the bail condition.
yes, lordship. That is the lordship. It should be a ground for the
But since nobody has appeared, it may not be proper to cancel it. Can you fix it for Monday or Tuesday, because since no one is there.
Yes, lordship. He is deliberately not appearing also, lordship.
You have to, whatever the hazard, you have to do the professional duty. Did we call for the case diary also?
Lordship, actually,
We can fix it on another date. And
case diary
case
will
diary,
go
and
for
then we
the-
can dispose it off
Yes, lordship.
if he's not coming.
Yes, lordship. One more chance may be given, lordship, for the.
Yeah, today, straight away it should not be.
Then lordship, then fix it for a disposal, lordship, on the next date.
Kindly check. Right, order dated 4/9/2025, the petitioner was granted interim bail with direction to, with conditions, one of which was to appear before the IO within 5 days was given, right?
Yes, Lordship. No, no, more than 1 month.
For his statement. And thereafter appear subsequently when required. None appears today on behalf of the petitioner. The learned additional PP has placed a status report of investigation before the court and contents on the basis of the same that the petitioner has not cooperated with the investigation and has not turned up for recording his statement in terms of the interim order, but has only tried to contact the IO on telephone when the IO was on leave. Diary is not there. No?
There is no, because
can get the
diary, last occasion I produced, but only status they call for Lordship. I'll on next date, Lordship, I'll enter, I can study, I'll produce.
The
Scan
case-
copy of the Lordship, scan copy.
It's an investigation case, right?
Yes, Lordship.
Get the original case diary. Save time.
Okay, Lordship.
Save time. From which police station? Yeah,
Lordship,
Itanagar.
yes, Lordship.
There's no problem.
Itap, yes, Lordship.
Yeah, no problem. Call for the issue fresh requisition for the case diary. Good stop. The interim is extended till the next date of listing. However, if none appears on the next date also, the court allowing the prayer of the prosecution in this regard shall consider disposing of the bail petition.
Bail
Yes.
application, Lordship. Yes.
Maybe we can keep a photocopy. Yes. But original you take.
Give your license. Date may be fixed, Lordship.
Oh, yes, sir. That, I didn't fix it.
No.
No, I have to fix a date.
Yes, Lordship.
Date will be necessary.
Yes, Lordship.
So when should I fix it? If the Itanagar, we can fix it Wednesday.
Wednesday, Lordship.
Okay.
Surely.
Wednesday would be
12th of November.
19th, no? Oh, sorry.
12th of
12.
November, yes. Okay.
Puro pa? No, sabli asan. No, sorry. Hearing is. Itu atas hearing. No, itu connected. This is not connected. This is separate. This is there. It is not connected. Just one. Let me plan it. Okay, what remains? No, this one is the 20 is left. 20 time range. That's over. Listed bills are all over. Okay. Then we call it. Yes. The bail application, the
Item number 34, unlisted bail motion.
you're there? Alo police station.
Yes, madam. Madam, this application has been filed under section 483 BNSS, seeking the release of the applicant. And madam, the gist of the case, I will simply explain, madam. Here, the applicant was the caretaker of one CCL, child conflict under law. So that CCL, my lord, that child, he took the gun of the accused person and he, in a sport hunting, he was trying to hunt one bird. And in the process, he shot one lady and she sustained some grievous injury because of that. And he was the caretaker only. So police, they arrested him also. So that is the gist of the story, madam. So a bail was moved before CGM Alo. It was rejected, citing that since he is also a police officer, there is every possibility that he might tamper with the case. But now, my lord, the current position is
The
that,
accused is a police officer.
yes, my lord. So only my lord.
Oh, that's why he was carrying that.
Yes. That is the one of the reason for holding that gun. And that is the present situation. Right now, my lord, the case is not at the nascent stage. It has already been, it has been, in thorough investigation has been done. He has cooperated. And furthermore, my lord, we are just praying that at this stage only CD may be fall, my lord.
Yes.
Yes, yes.
And try to give you a short date also.
Yes, my lord. Well, if possible, can it be fixed on 17th, my lord?
Just a minute.
Yes.
So, you have to guide me, I'm dialing the location. This is a police station.
It's Alo Lordship. Yomcha PS.
Yomcha PS.
Yomcha.
Can you get it on Monday or Tuesday more comfortable?
No, Lordship, that will be too early, Lordship.
We'll write short this one.
It would be, if possible, 17th, Lordship. 17th of November. Otherwise, before that, we okay.
Look, I have to see the schedule.
Yeah, how far is that?
I'll try.
How far is that police station? Which district?
This West Young district.
West Young.
I'll try to get it by
13, 14.
13 years, Lordship, 13.
Call for the case. I will like short. Call heard on council. Call for the case diary of. Help me with the case number. YMC, no? What's the full form?
Yes, yes. Why
Yomcha.
Yomcha Police Station.
Police station. PS case number. It is written as YMC only.
Yes.
Sumchang, you within bracket you write that. PS case number 2 of 2025. You mention it in bold sections. You can write later also. The accused was arrested on 15/10/2025. Heard additional PT. List the matter on 13.
Yes, Lordship. We'll call for the case study, Lordship. Scan copy of the case.
Call. No,
CD baby court, my lord. Can it be on 17th, my lord?
no, she was saying 17 only.
Yes.
I'll try, Lordship,
No, if
if that in, on
Se-
that.
se- no, so 17, he's asking 17.
17,
Yes.
you know.
Your original choice
No
of date.
problem, Lordship. If I
No,
try
he's
to get
he's
it by
seeking date. If
13
it's not
also.
late for you, no problem.
Yes, yes.
He was trying to give you an early date. No, I think, ma'am, investigation case, should we call for a original diary or scan diary?
Scan copy, because
On the
investigation
police
is
station.
still on, yes,
Okay.
Lordship.
Call for the scan case diary.
Much obliged.
Item number 30.
17.
I'll take a break now. So.
May, my lord. My lord, this is criminal petition, my lord, where we have challenged, my lord, the dropping of certain charges by the trial court, my lord.
Your status?
Yes, I am for the state, my lord, SIT, my lord.
Nice.
My lord, here the
The charges were not framed under certain sections.
charge has been framed against, charge has been framed against,
Them, but not under certain sections. So
Yes,
certain
my cons-
sections were dropped.
dropped in the session court, my lord.
So that's why you agree
Charge.
by that.
Yes, my lord.
So according to the state, those sections should have also come.
Yes, my lord. Definitely, my lord, if my lord will go to the facts, my lord, that is clearly attracted, my lord. My lord, here the, my lord, back to the cases, my lord. Two UTPs, my lord. Two UTPs. This case is related to my mob lynching, my lord. Two UTPs were dragged out by the, my lord, mob, my lord. From the police station, my lord. And they were mob lynched, my lord. That is the big fact of the case, my lord. And here the respondent, they are the accused person, my lord. They are the accused person. And they were the part of the mob, my lord. My lord, the challenge we made in this, the grounds we have taken is, my lord. Firstly, my lord, while framing of charges, my lord, only prima facie has to be seen, my lord. That is first ground, my lord. But here, my lord, the learned trial court, my lord, has weighed the probability value of the evidence, my lord. And secondly, my lord, since, my lord, 149 section has not been dropped, my lord, 149, my lord, that,
IPC sections.
yes, my lord, that is, my lord, common in object, my lord.
Can we have a look at the FIR?
FIR is, my lord,
to begin with?
Yes, my lord. FIR is the page number, my lord, 9 for additional affidavit, my lord. Additional affidavit.
My lord, there is one additional affidavit, my lord. that-
FIR is here,
Yeah, my lord.
Mm.
Yes,
just to inform that 19 February, right?
yes, my lord, 19 February. May I read, my lord?
Mm.
To police officer in charge, police station Teju,
Mhm.
dated 19 February 2018, subject FIR on lynching of two under trial prisoners lodged at police station Teju and thereof. It is informed you that on 19/2/2018, I was performing duty at PS Teju, paid Teju as day emergency duty officer from 8 hours. On the day at 12:05 hours, unruly mob numbering about 8 to 900, comprising of youth, aged women, children, etc., equipped with lethal weapons, arrived at police station Teju and suddenly ransacked the police station Teju. In the meantime, they broke into the UTP cell at the PS by breaking the iron grill gate and lockout of the iron gate and took out two UTP, namely so and so. They are the deceased person, my lord. Both presently residents of Tengafani so and PFPS were lodged as PS UTP in connection with Teju PS case number so and so. It is informed you that the police officials and personnel on duty at
Those were brought as POXO accused.
yes, my lord, POXO accused, my lord.
Okay, then.
And then it is also informed you that the police officers and personnel on duty at PS would be best able to control the unruly mob.
Mhm.
During scuffle, some police personnel on duty sustained severe injuries on their body. The unruly mob also stranded the police personnel on duty during the incident. CCTV, table, chair, iron grill gate locks of the police stations were damaged by the mob. So, my lord, the charges were framed under section, my lord, 120B. 120B, my lord, that is
Then now let's see the charge sheet,
charges, my lord.
the narration in the charge sheet.
My lord,
Then thereafter, we'll see the charge on.
my lord.
Right. Should be here. order framing charge does not have to be in very much detail.
Yes,
They can be brief also. In fact, very detailed charge orders could prejudice also, right?
my lord.
So, but however, when a charge order is framed, challenged, when a charge order is challenged, either with regard to the framing of the charge or say dropping of some charges, as in this case, then in a way you have to, we have to apply the principle of lifting the veil. You know, that the order may not be detailed, but we have to see what are the materials with regard to these offenses. But in this case, the order itself is quite detailed.
Yes.
So that could be, you know, that could throw some light, and beyond that, we'll see the materials. So which page I should go? Page
Page number
26.
26, my lord, 26.
Okay.
My lord, dear, learned trial court has framed 3 issues, my lord.
Mhm.
Para 6, my lord.
Mhm.
Number 1, if the accused has conspired to kill the said UTPs arrested in connection with the case number so and so. And number 2, sir, my lord, if the common intention referred as per under law section 34 IPC is attractive or not, my lord. So, and my lord, point number 3, my lord, if it can be concluded that the prosecution has established circumstantial evidence beyond reasonable doubt, my lord.
No, this cannot be done, of course.
Beyond reasonable doubt to draw a
You
conclusion
can
that
look at the materials.
accused person.
Appreciation of evidence
Yes.
is beyond the scope of charge framing.
And now, my lord, if there is the statement of the PWs, my lord, we have annexed the relevant PWs statement. That is page number 33.
Let us see page para 10. Para 10. Because let us see the reasoning of the court about dropping of the charges, because that is the crux in this matter, right?
My lord, then we can read, my lord, para 9.
9.
9, yes, my lord.
That will be better.
Page number 30, my lord.
10 is the conclusion, actually, it seems. Anyway.
May I read, my lord? This court opines that to charge someone basing on circumstantial evidence, the fact and the evidence of the case should be as much that it rules out all the possibilities to form a suppositions that makes the court to have even a slightest suspicion that the accused might have committed the said offense. This court further opines that to stabilize circumstantial evidence against an accused, there must be chain of evidence which are complete and which doesn't leave any room to suspect the accused person. This court has found that in the present case, all, my lord, this is important, my lord, all the PWs said to have been relied by the IO says that these accused person were present at the police station, my lord. PS, when the unruly mob entered into PS and drag out those accused, those killed UTPs. The PWs were also relied upon by the IOs to charge sheet the accused person are found to have stated that they have not seen these accused persons killing the said 2 UTPs. My lord, that is not relevant, my lord, because, my lord, if the as per, my lord, section 140.
Sir, what are the sections which have been dropped? So these
sections are, my lord,
10, so para 10, I think. I was failed to identify. Yeah, that's the from chain.
Yes, my lord.
The chain doesn't have to be looked at this is.
Yes, my lord.
That comes later, obviously. 10. Is not
Para
inclined to
10, yeah. In this circumstance, this court is not inclined to frame the charges against the accused person under section 120B. This old section will drop, my lord. 452, 120B is criminal conspiracy. 452 is house trespass for hurt, assault, or wrongful restraint. And, my lord, 353 is assault or criminal force to deter police servant from discharging his duty. And 302, my lord, IPC. This section, 4 sections will drop. This court rather is opinion that framing of charges against these accused persons under section 120B and a further proceeding of the case may not lead the conviction of this accused
No,
person.
you don't have to. This is settled law.
Yes.
Okay, well, I cannot speculate on. You know, I can see that if the materials are taken on their face, do not make out anything.
Yes.
Then, and of course, there's a grave suspicion test also. You know, if there's a suspicion, little bit of suspicion, not very high
my lord.
suspicion, then he can discharge.
Yes.
Then the learned judge then frames charges under.
Frame charges under.
In the materials frames under
147,
148,
147, 148, 149.
Oh, the homicide aspect was dropped.
Drop. For
On the
148,
ground that they were not sufficient material to say that frame charges, on the ground that they were not present there.
yes,
That's
they're
what it
saying like though they may be present, but no one has seen them.
147,
147 is rerouting, my lord, and 148.
yes.
48.
Charges dropped to a 120B, 452, 353, 302 IPC.
Yes, my lord.
And sections charged were
147,
sections
147, punishment for rerouting, 148, rerouting with deadly weapon, and 149.
and PDPP Act.
And PDPP Act, yes, madam. Section 3 of PDPP Act.
Oh.
And now, my lord, may peruse the statement of the PWs, my lord, which we are relying on, madam. Page number 33, from page number 33 to 42, madam. Page number 33.
Yes, I didn't see. No, you carry on.
Yes, page number 33, my lord. These are the, my lord, statement of the police officers, my lord. So, my lord, relevant page is page number 34, my lord. Page number.
Yes, I am on 34. Yes. Whether
Page number 34, my lord.
yes, sir.
The question.
Question.
Yes, whether Legam Takalang is there. These all are the, my lord, respondent hearing. They all are the accused person hearing.
Yes, this
Wait,
for 1, 2,
yes.
3, 4, 5.
Yes, were part of the mob who have lynched so and so. That is just answer. I did not saw them killing the two UTPs number so and so, but they were definitely part of the mob. And my lord, next page, my lord. Page number 36, my lord. Question.
Yes.
Yes, ma'am. Question. So question number 1. Can you identify anyone from the mob? Yes, I can identify Legam Takal, and this is respondent number 1 hearing. President of all Mission Union. He came to PS and had discussion with me about rape and murder case. This Bohenso Full, respondent number 3 hearing, was also there in the mob. And question number 2, whether this Legam Takalian Bohenso Full was part of the mob that ransacked PS and lynched 2 UTPs. Answer, I did not see them physically assaulting both the UTPs, but they were part of the mob. And next. Page number 39, madam. Here also same question and same.
I'll just take 2 minutes.
Yes, madam.
Toilet break. So this vicarious liability, as you from your past experience would say,
yes, madam.
the vicarious liability in criminal law in mob-related matters is a very risky area. It's a very tricky area. You know, a group is there, mob is there, and who's participating, who's not.
Yes.
You know, that's a very tricky area. But the thing is that you have to be careful. But all the things we will see, of course. And so probably the learned judge was quite influenced by this, that how the witnesses state that they did not see them.
Yes, ma'am. Here again, same, my lord. Page number 42. That they were the part of the mob, my lord.
Right.
So now, my lord, may I read the 149 IPC, my lord. IPC,
IPC. That one. Yeah. 149. Offenses committed by an unlawful assembly,
Yes, my lord,
furtherance of common object.
my lord.
Yes.
Every member of unlawful assembly guilty of offense committed in prosecution of common object. If an offense is committed by any member of an unlawful assembly in prosecutions of the common object of that assembly, or such as the member of that assembly knew to be likely to be committed in prosecutions of that object, every person who at the time of the committing of the offense is a member of a same assembly is guilty of that offense. So, my lord, here what role this accused person has exactly played during that whole situation, that will be only identified during the trial only, my lord. So prima facie, my lord, they were the
That would be a matter of evidence.
yes, my lord. So prima facie, my lord, as per the statement of the PWs, my lord, they were the part of the mob, my lord.
Whether there was an unlawful assembly, one section of unlawful assembly has already
Yes,
been
yes, already
framed.
the this was
Whether
not,
there was an unlawful assembly, whether
yes.
whether oh yes, whether there was an unlawful assembly. Number two, whether these persons were a member of that unlawful
Yes,
assembly,
yes,
prima facie.
prima facie.
And secondly, the first part, the first limb, in my opinion, in prosecution of common object of the assembly, that would be a matter of evidence.
Yes,
It's not
ma'am.
possible at
Yes,
this moment.
yes.
But whether such offense as members of the assembly knew likely to be committed,
My lord,
you know,
my lord.
this part, whether
Yes.
they are prima facie matrix.
Yes,
If
ma'am.
yes, then 149/302 will come.
Yes, my lord. So, my lord,
That whether this assembly can be attributed with the knowledge prima facie that in such a nature, in the circumstances in which this mob had come,
my lord,
there was a possibility of killing of the person.
my lord. Yes, my lord.
This is the question,
Yes, my
in my
lord.
opinion.
So, my lord, prima facie, my lord. Prima facie, my lord. This accused person were, my lord, part of the, my lord, part of the mob, my lord. And my lord have perused all the statement of the PWs, my lord. They have all stated the same things, my lord. This accused person were the part of the mob. They were present at the police station, and they were very much were the part of the mob. But they stated that they have not seen them killing. But that is a different case, my lord. But up one section 49, if it is attracted, my lord. One section
Vicarious
49,
liability.
yes, my lord. If it is attracted, then why, my lord, one other section has been dropped, my lord? That is, my lord, our contention, my lord. If 149 is attracted, if they were the part of the mob, so other section has to be also inserted against them, my lord.
So 147 is rioting.
Rioting, my lord.
148 is rioting,
Rioting armed with
deadly weapon.
deadly weapon.
149 is the thing.
That.
So 149 though, see, 149 though it is considered an offense, but it's not a, in a way it's not a, it will always be something.
My lord,
What is the offense? It is linked to something.
my lord.
Like 149, what offense has been committed by that common unlawful assembly,
My lord.
right? So in this case, 149 with regard to 448, it has been given.
My lord.
Common object of a unlawful assembly to commit what offense?
My lord,
Trespass,
trespass as well as
criminal trespass.
my lord, as well as 302, my lord. That they were the, my lord.
No, according to the charges framed, it is common object of the unlawful assembly was only to commit trespass. Criminal trespass. Get my point, no? Because 448 has been there.
Yes, my lord.
Substantive
Criminal
section.
trespass and
353 has been dropped also. 353.
no, that is not been dropped, my lord.
353 is there.
Yes, my lord. Not dropped, my lord.
I wrote it wrongly. 353 has been charged.
Yes, my lord.
But 120B, 452 and 302
Has been dropped, my lord.
dropped. 353 is there.
353 is also
I think it's dropped.
dropped, my lord. This is also dropped, my lord.
Anyway, so.
So, my lord,
The trial is in progress.
trial is in PW's, my lord, is now it is in PW's, my lord, is prosecution witness, my lord. My lord, page number 8 of our petition, my lord. There is page number 8 of our petition, my lord. 7, my lord, 7%.
Okay.
Para 3, my lord.
Para 3.
Para 3 years, my lord. For that, the learned trial court has lost sight at the stage of premium charges, and the court is expected to seek the evidence for the limited purpose to decide if the facts emerging from the records and document constitute offense with which the accused is charged. In other words, only prima facie is to be seen, and the probative value of the evidence is not to be looked into. Vis-a-vis, the court need not to satisfy that the accused will ultimately end in the conviction and proceed with a simple satisfaction that the accused might have committed the offense he is charged with. And my lord, next para, my lord, next page, my lord, page number 8, my lord. Para 5, my lord. Roman 5. It is humbly submitted that the perusal of the ensuing order will reveal the learned trial court has erred in manner of its adjudication, as firstly, it has taken common intention, rather than common object, to determine the liability of the respondent, my lord. My lord, the ingredients of 149 is common object, my lord. But here in the judgment, my lord, the learned trial court has said that there was no common intention was here. But my 149 it talks about common object, my lord. So there is no question of common intention here. Since 149 is not dropped, my lord. Secondly, it has burdened the prosecution with stabilizing circumstantial evidence beyond reasonable doubt at the stage of framing of charges, my lord. For 6, my lord, at the outset, it needs to be stated that ensuing order is self-contradictory. By not dropping section 147, 148, 149 of the IPC, read with section 3 of the PDPP Act, that the learned trial court has admitted that common object exists. Common object exists in the circumstances of the case. However, it defies any explanation as to how the respondent had the common object to riot and damage public properties, but did not have the common intention to commit the offense under punishable under section 452, 353, 302 of the IPC, which were the direct consequences of the rioting executed by the unlawful assembly of the people. And para 7, that the learned trial court has failed to appreciate that from the statement of Subhas Devnath, prosecution witness, who categorically deposed that few members of the respondent had gathered a large number of the mob at the at the circuit house Teju. After about an hour before the lynching, it can be gathered that they were the part of this unlawful assembly, which ultimately committed the lynching of two alleged accused detained for committing rape and murder of the minor child. Further, the other prosecution witnesses have categorically stated that all the respondents were present during the lynching and were far to the mob that lynched the two alleged accused persons. They had the common object as well as the knowledge of that was likely to be committed in persecution of that object. Additionally, the learned trial court has erred in assuming that there could be two gatherings of nearly 1,000 people merely an hour before lynching at mob, lynching at Teju. So, my lord, I would like to rely some judgment.
Ma'am, you're appearing for the respondents?
Amicus not.
Or amicus?
Yes,
For all the respondents?
for all the respondents.
A small judgment, my lord, on it. Three.
6 of them, right? 6 of
5.
Huh?
5, my lord, I think.
This, I saw
I think.
Asado Naldo.
Yes, my lord, 6. My lord, the first one is regarding the 149 IPC, my lord.
Mhm.
Para 4, my lord, para 4. May I read, my lord? Where a member of the unlawful assembly is named as an offender who committed an offense for which the members of unlawful assembly are liable under section 149 IPC, and evidence that the trial is insufficient to establish that the named person committed the act attributed to him, he may still be convicted of the offense if it is proved that he was member of the unlawful assembly and that the act was done by some members of the assembly in prosecution of the common object, or which the members was likely to be committed in prosecution of that object, my lord. And rest is, my lord, not relevant, my lord. And next is, my lord, next judgment, my lord. Page number 4, ma'am. Para 11, my lord. Para 11.
Soma Chakravarti, this one.
Yes, ma'am.
Para.
Para 11, my lord. Page, last page, ma'am. Last page. It may be mentioned that the subtle legal position as mentioned in the above decision is that if on the basis of material on record, the court could form an opinion that the accused might have committed offense, it can frame the charge. Though for conviction, the conclusion is required to be proved beyond reasonable doubt that the accused has committed the offense. At the time of framing of charges, the probative value of the material on record cannot be gone into, and the material brought on record by the prosecution has to be accepted as true at that stage. Before framing a charge, court must apply its judicial mind on the material placed on record and must be satisfied that the commitment of offense by the accused was possible. Whether in fact the accused committed the offense can only be decided in the trial, man. And next judgment is, my lord, page para 12, my lord, para 12. Para 12, page number, para page number 3, my lord.
Yes.
This is about Landy order.
Yeah.
Yes, during the discharge. If there is no legal requirement that the trial court should write an order showing the reasons for framing of charges, why should the already burdened trial court can be further burdened with such extra work? The time has reached to adopt all the possible measures to expedite the trial proceeding and to chalk out measures to avoid all roadblocks causing avoidable circumstances, avoidable delays. If a magistrate is to write detailed orders at different stages, where merely because the counsel would address argument at all stages, the snail pace progress of proceeding in the trial courts would further be slowly slowed down. We are coming across interlocutory orders of magistrate and session court running into several pages. We can appreciate if such a detailed order has been placed for culminating the proceeding before them, but it is quite unnecessary to write detailed order at other stages, such as issuing process, remanding the accused to custody, framing of charges, passing over to next stage in the trial. It is a salutary guidelines that when orders suggesting of granting bail are passed, courts should avoid expressing one way or other on contentious issues, except in such case those falling under section 35 of NDPS. Here, my lord, our main contents is, my lord, since my lord, or the order of the Lana Trial Court is very lengthy, my lord. So that I want to burden my lord through going through all the para, my lord. But here they've stated that this if we charges again the the section provisions which they have drawn, they may not be end into conviction. But that is,
No, that is,
yes, that is.
I
that's-
cannot speculate. at
Yes,
this stage.
yes, that cannot be, cannot be the approach of the trial court during the premium charges matter. Here, prima facie material is well established against the accused person that they were the part of the mob where the mob lynching taken place.
Yes, this, there, one, you know, caveat to that, what I said. If suppose that one cannot speculate on the conviction
My lord.
at that stage, but
Right.
however, suppose all the materials taken, even if they are accepted, that these are the materials accepted, then also there will be no possibility of
Yes,
conviction.
madam.
Then you can,
Yes, my lord.
then you can discharge.
Yes, ma'am. So, my lord, here, the PWS category stated that they were the part of the mob. So, section 149 has not been dropped against them. So, they were, when they were the part of the mob, who were this mob lynching took place, my lord. Now they had dropped some section but yes, they were the part of the mob, but they may not be the one who killed the mob, who killed the deceased person. When they were the part of the mob where the deceased was died, my lord, how they can make an opinion that they may be the part of the mob, but they were not the one who killed the deceased one.
True.
So, my lord, this matter was also this matter was also taking cognizance by our principal bench, my lord. So, however, this was, my lord, disposed of, my lord. My lord may have various.
Another incident, different incident.
Same incident. my lord. Says this was so motu cognizance was taken by our
PIL,
principal
that's
bench.
a PIL.
Yes, my lord. So, wherein, my lord, it was disposed of directing all the police station in our Arunachal Pradesh to install CCTV footage, my lord.
people involved in the unruly mob were the people who gathered in the circuit house or the students of Teju schools or colleges. Now, Lordship, why I wanted to point out the statement in page 33 is because of this, Lordship. Consistently, page 33, then whatever he has pointed out, page 35, then page 38, all these statements, Lordship, page 40 also, the picture that they have given through this statement is the respondents, accused persons, had gone to the police station in a decent manner, so to say. They were inquiring about the rape and murder case, inquiring about those two UTPs. Suddenly, a mob arrives and they start ransacking. There is a disconnect because when they were discussing, that is what they're saying. I was in the IO room updating my, this is page 33, updating my case diaries, and members of AMSU were discussing the matter in the OC room. They were discussing the matter in the OC room, that is the officer in charge, I believe. All of a sudden, unruly mob of students, numbering countless, equipped with little weapons, barge into the PS building, shouting to hand over the two accused persons. So there is a disconnect between those people who were inside the room discussing the matter and the mob which has suddenly come. The only statement thereafter saying that they were part of the mob. There is nothing to show that thereafter they joined the mob, because at that point of time, they were inside the room. This is what every witness has stated. This we also will find on the front page itself. At 12 o'clock, they were discussing, they were inside the room, then uncountable people came all of a sudden, then these things happen. Then the question is asked whether they are part of the mob. They are saying, yes, I can identify that these are the people, they were in the mob. Now, to say that they were in the mob, there has to be a part where they had joined the mob, because at that point of time, they were inside the room. There is nothing to show that they were shouting, sloganeering, they were inciting the mob. There is nothing to show. There is a total disconnect here, Lordship. This is probably why, of course, the language used by the learned trial court saying that there is no evidence, that it will not go to some conviction, that sort of thing is not correct. I believe that is not correct. But Lordship will see. Lordship will see some statements made by some of other witnesses, which are, Lordship, ahead. That will be, I think, page 55, page 59. Page 55, one of the, not here, Lordship, in the charge sheet. I was not given, so I had seen from here. There, it was mentioned that a mob was wearing mask. These people are easily recognizable, these respondents, because they are members of the AMSU, Student Union. So that is probably why.
Well known in that area.
Well known. But in page 55, your Lordship will see one constable has stated that the mob was wearing mask. That means, Lordship, they were not necessarily part of the mob.
Page?
Page 55. Not here, Lordship, but in the charge sheet, I think.
I'll see.
Yes, Lordship. Page 55. Then also at page 59, there is a statement by one constable, Molester Payang, that when he arrived at 12 o'clock, he noticed the dead bodies on the traffic point. That is outside the police station. Till 12 o'clock, according to the statements made, till 12:05 o'clock, they were still inside the police station. But according to this witness, by 12 o'clock, the dead bodies were already there at traffic point. So there is a disconnect here also. The Lordship, common object, Lordship knows that first of all, there has to be some unlawful assembly. There has to be some commission of an offense. The common object has to be inferred from the act. Yes, it not necessarily every person's conduct, every person's act has to be culled out. Yes, yes. It not necessarily a covert act, but something common object has to be inferred. Now, if there is nothing to
As
show,
I said, no, just
Yeah.
sorry to interrupt you, that the first two, the first ingredients of the section are comparatively easy.
yes,
That there was an unlawful assembly.
yes.
That factual determination. is
Initially, it was
comparatively
not unlawful.
Yeah, there is a unlawful assembly to determining that comparatively easy, whether a person was member of that unlawful
Unlawful
assembly.
assembly.
You know, that also little more difficult, but then that is also maybe possible. But the most difficult element,
Yes.
most difficult ingredient of the offense is that as a member of the unlawful assembly, he knew that that offense was
Yes,
likely to
yes,
be
yes.
committed.
It is very,
That's
very, very difficult
That's
to,
difficult and risky.
yes, Lordship.
Because if one is not careful,
Yes,
there is risk of missing out also, real accused and also false implication.
yes, Lordship. What I'm trying to say, Lordship, here is, in fact, in my, in my opinion, in fact, they should also not have been even booked under unlawful assembly, because it was not that when they entered the police station, it was not with
According to your contentions, they had gone to inquire about a police.
yes, they had gone to inquire. And there is a, like I said, Lordship, if your Lordship will read the statements again, there is a disconnect between what the mob did and what was being done at that point of time. There is nothing to show that there was some kind of connection between the mob that suddenly entered and the people who were already present there. There is not even one statement saying that there was instigation. If that being the case, simply saying that they were part of the mob, how? They were simply saying that they were part of the mob just because they happen to be the most recognizable faces at that point of time. Thus, their being in the station at that point of time, and it happened coincidentally happening that mob had entered and had committed, does that connect them? In my humble submission, it does not. That is why I'm saying, Lordship, that in fact, those charges which have been framed against them, that also should not have been framed, but since they are not challenging that at the moment, I'm not going to say anything on that. So that is my humble submission, Lordship.
Will you reply?
My lord, there is one statement, my lord, page number 42, my lord. Page number 42, my lord.
Just
My lord, he is caretaker of Circuit House, my lord, where the meeting was
let
taken
us
place.
read the complete statement.
Yes, yes. Where yes, may I read, my lord?
Working as a caretaker of Circuit House.
On being examined, I have to say that I was caretaker of Circuit House Teju. On that is the date of incident, my lord, 19/22. I was working in Circuit House, serving as assistant guest a huge number of student youths has gathered at the compound of Circuit House. These were students. There were students all over the garden Circuit House. Some came inside to have water. I don't know why they came Circuit House and why they have gathered. After 10 or 15 minutes, all the students left the Circuit House and it was completely empty. In the evening, I came to know that two Adivas accused person. In the evening, I come to an accused person. They have been killed by public, but I do not know who did it. That's I have to say. My lord, question number 2, my lord. Since you are staying in Teju for many years, you might have identified some prominent leader of the group, because the student community leaders usually use IV Circuit House as their venue for meeting or for accommodation during their movement. Yes, answer is, my lord. Yes, one. This is Takaliang. He is respondent number 1 herein. Chokya, respondent number 2 herein. Who are local Mismi community leader were also there in the meeting. I also doubt some students of IGG College Teju were also there in the said group. So, my lord, this student union, before coming to the police station, they were gathered at Circuit House, my lord. There where the meeting was taken place, my lord.
This Chokidar statement about the being present there, he was mentioning about Circuit House,
Yes.
not
Yes,
police
Circuit House.
station.
Yes.
No,
Not
no
police
Circuit House.
station, Circuit House.
But
Yes, Circuit House.
this is the case of the prosecution that before entering to the Circuit police station, they had meeting conducted meeting at the circuit house, my lord.
Pre-planning,
Pre-planning, my lord.
I mean, allegedly.
Yes, my lord. So, my lord, they were the part of the mob, since not necessary that all mobs has to be assembly in one, my lord, one particular place, my lord. They were the student leaders, so they were the one who first entered into the police station, my lord, to make an inquiry about that one UTV, my lord. So after that, after a few hours, this mob entered. So that is they were the part of the mob. They were the one who were the leading this mob, my lord, the student leader, my lord. They were the one who entered into the police station first, my lord. And after that, this ransack taken place, my lord. So, my lord, during framing of charges, my lord, only prima facie has to be seen, my lord. Probative value of the evidence can be looked into during the trial, my lord. So, my lord, in the, my lord, charge sheet, my lord, prima facie, my lord, it is clearly stated that they were the part of the mob. So this is, my lord, enough to frame the charges against accused person, my lord. What role they had played, that will be only determined during the, my lord, trial, my lord.
You are seeking addition of all these drop sections.
All these drop sections.
Conspiracy,
Yes, my lord.
452, 353,
Yes, my lord.
302,
Yes, my lord. Because they all are connected matter, my lord. Since 149 is not dropped, my lord.
especially for 302.
302, my lord. Since 149 is not dropped, 149 is not dropped, that means, my lord, they were the part of the unlawful assembly, my lord. Because
This trial is now proceeding before magistrate or session.
no session.
Because of PDPP.
PDPP.
No, otherwise, all these are, others are magistrate tribunal.
No, my
I
lord.
think it should be before the magistrate.
Magistrate, my lord. I'm sorry, my lord. It is
No, no,
before,
no.
it is before magistrate, my lord. Since 302 has been dropped, my
Oh,
lord.
yeah.
Yes, my lord. So, my lord, since 149 IPC is not dropped, so clearly, my lord, they were the part of unlawful assembly. But still some section has been dropped, my lord, because nobody has seen them killing the accused person, my lord.
That's all.
My lord, that's
Heard. So, Honored Public Prosecutor. For the
all.
state-
L. Kurdu, SPP, SIT.
The state represented by the prosecution. State/prosecution has filed the instant criminal petition agreed by the order dated 13/5/2022, passed by the it's sessions, I think it's sessions court.
No, my lord, the discharge has.
Oh, after that it.
Yes, after that was.
Yeah. Charge. It was committed and
Yes,
went back.
yes, ma'am.
Learned Session Judge Teju in Sessions case number 3 of 2022. Whereby though charges were framed against the accused persons, slash respondents under some of the penal provisions, but the charges, they were discharged of charges under 120B, 452, 353, 302 IPC. Full stop. The case arose out of an alleged incident of mob lynching leading to the death of 2 persons who were accused in a POCSO case involving a minor girl aged about 5 years. Full stop. The case was registered as Teju PS case number 20 of 2000. No, sorry, this is not the one. Our case, this one.
This number.
PS case. Right. Must be in the order.
2218.
22 of 18.
Teju PS number 2218. Under section 120B, 147, 148, 149, 452, 353, 448, 302 IPC. Read with Section 3 of
PDPP Act.
Act.
Heard the learned public prosecutor. I'll mention as SIT.
My lord.
Oh.
SPP SIT.
Special Public Prosecutor SIT at length, who also submit some case laws. Those stuff. Should I mention about the earlier? No necessary. Earlier councils.
No, just amicus.
That's it. The concerned accused persons are the 6 respondents herein. Then they are represented in this matter by N. Dangle, learned amicus curiae, who has also addressed arguments on the matter and supports the impugn order containing that there is no infirmity in the same. There's no time to dictate now. No? So the result will take some time.
Obliged.
In any case, it would have taken some time to go through it.
Lordship.
I'll need that back.
Yes, Lordship may see page 55 and 59 of the charge sheet, the statements of the witnesses, which were not annexed in this petition. So. And also that in the supplementary charge sheet, it has been made clear that there was nothing found in the phone. Obliged.
I should be able to dispose it by the middle of next week. Hopefully.
Obliged.
Obliged.
So,
Actually,
yeah.
it is happening.
Mentioning, we have to mention the remaining matters. No? This is 30.
Item 31, Lordship, it is coming almost after few months. But because it is coming in the hearing list, it is not being.
That's the problem here also. It's
Now, Lordship, if I make a prayer, Lordship, here what has happened, Lordship, the sentence has not been suspended.
What is the sentence?
Sentence is for 10 years with
Under what?
1 lakh.
NDPS.
NDPS. Now, Lordship, if I may kindly make a prayer, Lordship, although the paper book has been prepared, Lordship, if the IA can be taken up at any time next week or thereafter, because Lordship is languishing in jail.
Commercial one, not so commercial one.
Commercial one.
Commercial.
It is ready, Lordship.
It's better to hear the matter, I think.
Lordship, I am.
Criminal appeal, better to hear the matter, because I'll tell you something. You'll be aware also. There's this very leading judgment of Dadu versus State, Supreme Court. No? That some amendments were made in the NDPS Act. That is the backdrop. So just to refresh us. Doing away with remission, doing away with appeal, suspension of sentence, everything was done away with. Remission is not possible. Sentence cannot be suspended.
37.
Nothing, yes. So that was constitutional validity was challenged. And that was not, the constitution did not set aside completely, but watered down. So it said that still no remission. Okay. And, but said that suspension of sentence is permissible. Suspension of sentence is in your this NDPS conviction is possible, but and bail can be given. However, you have to fulfill the conditions of 37.
Now, here, Lordship, I will, if I may kindly submit, I will take your Lordship for those, the evidences or the materials, Lordship will see that there is total disregard to the NDPS Act. The records of 37 will not be applicable at all. Total disregard.
Yeah, my point is that, we are all learning students of law, learning all the time. My point is that after a conviction or prima facie, it is almost impossible to say that 37 requirement, that he is not guilty. Now, he has been held guilty by court after a trial. Okay. Even if you discount that, and you say that on the basis of these materials, prima facie one can say, think about it, what I'm trying to say, if I've understood correctly. Maybe I'm wrong also. That, of course, this is the law of the land, Dadu, but the interpretation of this on the ground, that after framing of after the trial conviction of a person, recording of guilt, it is per se almost impossible to say that he is not guilty under 37. Right. Suppose you leave aside that aspect also. And as learned counsel rightly said, that after evaluating the evidence in a suspension, in a 389 petition, earlier 389 petition, you say that yes, 37 is not applicable, he is not guilty, right? Won't that amount to prejudging the appeal itself?
That is why.
That's my dilemma.
That is why, Lordship.
While studying this law, this is what as a student of law, this is what I came to my mind, and I try to understand. This is something we have to
That is why,
deliberate
Lordship,
on.
I'm ready with the hearing. Now, only difficulty, Lordship, it is coming up as item number 3, 4 in the hearing list. So it is not reaching. If it can be taken up in the top of the list, Lordship, as a hearing, Lordship.
No, no, early matter. I mean, how long?
Lordship, he is behind the bar.
There was a
after-
special case today, so we had
Two paper book.
today's case was special
Yes,
actually.
sir.
No, no, I
That's
understand.
otherwise it's
had
a
got
normal
nothing
case.
to do with-
Here, I think in Itanagar, reaching of criminal appeals should not be that much of a problem. Single bench criminal. appeal.
Lordship, it is
Lordship,
not-
I
never-
don't know the objective situation.
Lordship, there was only
Never reaching the bad luck.
only the
with me.
senior Lordship, this my senior friend Lordship, his hard luck Lordship. Every
It is
time
my hard
whenever
luck.
Yeah, no, this problem I've encountered there, but here it should not be.
Today I was very happy.
Today I have a long board also because
Today I was very happy looking at 31. I thought it will reach. But
no,
there were
sometimes no, they took
very
some
serious issue that
matters took time. This matter continued from yesterday.
Lordship.
So so we need to as students of law we need to understand and work on Dadu more, and many subsequent interpretations of Dadu maybe in other high court decisions, our high court decisions of this. Secondly, what I understood is that it's almost very, that means if you have to apply 37 after a conviction, it's very challenging. So it is best is to hear these appeals itself. Generally speaking, I feel this is the rather than entering into that kind of adventure, kind of, it's possible that that it is better to take it up and for hearing, but then hearing has its own waiting list queue. That's a problem.
That
That's
is
a
only
problem.
my prayer with your Lordship that
How long he's been in custody?
Lordship total 894 days. He is
That is,
UDP.
No, the say no.
898 days.
So he's 10 years conviction, right? So that means minimum sentence was given. Minimum
Because Lordship, there is nothing. Sentence itself was, I should say very humbly, it was perverse, Lordship. Lordship will, when Lordship will go through the records, Lordship will understand, Lordship.
So third A Bhattacharjee, learned counsel for the appellant, who stated to have been convicted and sentenced under the NDPS Act and serving out a sentence of 10 years rigorous imprisonment.
Okay.
Full stop. He has also preferred a IA interlocutory application seeking suspension of sentence and bail. Learned counsel, who's an outstation counsel, submits that on several occasions the matter has come up before the court but not reached. Stop. And he prays for taking up the interlocutory application or in the alternative, the criminal appeal itself. Stop. So can we do one thing? That say fix it on Thursday or something. I don't know what board will come and fix it at 2 o'clock. That can be one option. Top of the list, it will not be fair.
It will take all day, Lordship. Half of the.
No, top of the list only everything has to have a reason, right?
No, top of the list in the hearing list. In the hearing. I'm not saying top of the list in the entire list. Lordship. In the hearing, if it comes as item number, then I think we can make an effort. Lordship. Can it be on 14th?
2 is even better because sometimes the admission itself takes. Yes, it takes sometimes. Hearing first item also doesn't reach. 2 is safer. When since you are coming from Guwahati, when can you?
Can it be on 14th?
No, it can be later also. 14th next, not necessarily next week. Can be after that also.
Then as you have done, let it be fixed with the registry, Lordship.
Registry. Okay. And let the matter come up after.
Due course of the day, only due course of the hearing.
Let it be come up. No, not due course. It will take a long time.
No,
You only say that.
due course here it will be little different.
3 weeks, Lordship.
And even those things you are not remediless. Suppose it is not coming for long, you can always mention.
Yes,
Yes, Lordship.
let it be after 3 weeks then, Lordship.
It's the matter after 3 weeks. Maybe you can seek a date and come again.
Same prayer for item number 33 also. It is also any basis.
This is also any case. Same conviction, 10 years.
same convict.
Nice.
And we are relying upon the same set of judgments.
Same set of judgment, but different accused, different case. right?
Different accused, different.
33 also, one same order, list after 3 weeks.
3 weeks.
Can you do it together or separately one fix?
May come separately to be better
Better,
in one list. But we are relying upon the same set of judgments.
then it will be easy for you.
That will be together. Lord.
But may not be, it will take a lot of time, the separate arguments have to be made.
That
for
will
you.
be up to the honorable court.
You can fix one after 4 weeks and one after 3 weeks.
Yes, sir, that will be.
After, second one after 4 weeks. Okay.
I'm diplomat.
This matter, you just write like that. FAO, anyone from the 32? You there? It's this injunction.
No, my lord, suction appeal, my lord. My lord, we fix on Tuesday, my lord. If possible, my lord.
Tuesday.
Yes, my lord.
I can fix it, but I don't know what list will come. No, no, what is
Top
the
of the
board? We
hearing.
don't know.
My lord,
Paucity of, could not be taken up due to paucity of time. Allowing the prayer of the learned council in this regard, list the matter on 11/11.
yes,
Tuesday
yes,
is
my lord.
11.
11.
We'll try.
My lord, top of the hearing list, my lord, if possible, my lord, kindly. Hearing list, top of the hearing list, my lord, number 1 in the. Because, my lord, this matter.
I'll suggest this thing. Let it be like this only, because as I said, now sometimes hearings also don't start. Let it be like this. After seeing the list, you can make a mention for taking up at 2.
Okay,
if
my lord, much
necessary,
of that.
right?
Much of that.
It all depends on the list.
Yes, my lord. My lord, there's interim also.
Interim order granted shall stand extended till the next date of listing. Succession appeal, succession certificate or
Appeal, my lord.
probate.
Appeal.
Okay.
Right.
Okay.
There is one item 33 is there, Lordship.
I've mentioned.
Same
Okay, Lordship.
after 3 weeks, after 4 weeks.
Not 4 weeks.
Order will be similar. Okay. Have a nice weekend.